Good morning.
Ma'am, we will start the event shortly.
Sorry, can I get your name, please? I could not hear your name.
Ma'am, I'm the anchor for the today.
Okay.
Yeah, so I'm
What's your
Jableen.
name? Sorry, I could not get your name.
I'm Jableen Kaur.
Chandreen.
Prableen.
Can you just spell it?
Prabhleen. Prableen.
Prableen. Okay.
Yeah, Kaur. Ma'am, we will start this event shortly. Okay.
Okay. Just a second. I have few queries. Like you will be they'll be entering one by one.
Yes, ma'am. Once the event starts, the teams will enter one by one.
Okay. So 8 minutes. You'll be showing them the time slots, right?
Yes, ma'am. It will be presented on the screen itself.
Okay.
Any other queries, ma'am?
Nothing. I just wanted to know like the first slot will be from 10 to 11, right?
Ma'am, I will
Yeah.
just confirm that. Yes,
Yeah,
ma'am.
because yes, it's only 1 hour, so make sure they complete it within the time. After which there'll be no not given any extra time for that. Okay,
Yes, ma'am.
and please ask them to introduce once they come with the number which their code is the team code, so that it is easy for me to mainly assess them on that.
Okay, ma'am. We will keep this in mind.
Okay, thank you.
Thank you, ma'am.
And also, probably, are we supposed to ask anything, or just we have to mainly take a note on all the criteria which has been given to us?
Ma'am, uh, uh, ma'am, you can ask any questions you like between their debate.
Okay.
Hi Anita, hi Praveen.
Yes, sir.
Praveen and Anita, I think this being a debate competition where we are only assessing the qualities of the students who are presenting, it is not advisable to ask them questions unlike in a moot court. Like if there is a moot court, a judge can ask questions on law or clarity. But if they are in a flow in a debate where they are just presenting what they have prepared, I think in my personal view, it would not be advisable to interrupt them when they are speaking.
Yes, that's what I had a doubt, because in
Yeah.
debate
So
it's only
Anita,
between the two.
yeah. What my suggestion would be, Anita, that we should just hear them and judge them on the criteria that are prescribed in the Excel sheet and give our marks.
Okay, okay.
Yes, sir. Thank you so much, sir.
Thank you.
Sir, can you please switch on your video? It's a kind request. Thank you, sir. Everyone, please join as we are about to start shortly. And please join according to your team codes. Please, everyone, it's a kind request to join your team code with your team code.
Can we start probably?
Yes, sir. We will starting in another 2 minutes. Just waiting for some participants to arrive. Just in under 2 minutes. Thank you, sir. A very good morning to our respected judges, Mr. Pravesh Menon and Dr. Anita A. Patil, and to all the participants from the various institutions of India. I, Praveen Kaur Gill, welcome you all to the third National Virtual Debate Competition 2020 organized by Center of Legal Studies, Geeta Ratan International Business School. Our first judge is Advocate Pravesh Menon. He is a senior partner at MZM Legal. Sir chairs MZM's legal criminal litigation, white collar and regulatory defense practices. He is an advisor to prominent national and multinational operations at the board level of issues of cross-border bribery, corruption, fraud, embezzlement, and money laundering. He has over 20 years of niche experience in trial and appellate work before national and international in the fields of financial fraud, money laundering, bribery, corruption, extradition, cybercrime, and other historic areas. He also has the experience of working on high-profile criminal investigation initiated by India's premier investigating agency. His invaluable contribution to the firm ranges from his oratory skills to his excellent drafting, which has been the backbone of his firm's success over the years. A warm welcome to you, sir. Our second judge is Dr. Anita A. Patil. Dr. Anita A. Patil is an associate professor of law with Ramaiah College of Law in Bangalore. She has done Master in Law 2012 from Karnataka University Dharwad with 2 gold medals in specialization of business and trade laws. She has qualified UGC NED GRF Fellowship Award in December 2012. She has joined the chair on consumer law and practice from National Law School of India University, Bangalore in July 2012. She has successfully completed her PhD on a critical study of legal framework to control misleading advertisement in India with special reference to food, drugs and cosmetics from NSLIU, Bangalore in 2018. In June 2016, she is also qualified as accredited mediator in negotiation and mediation at Indian Institute of Arbitration and Mediation in Mediation Training Program in Cochin. We welcome you, ma'am. A special thanks to respected judges for sparing their precious time. I may go further. A basic rule to all the participants that they are not to leave the virtual debate room and to stay until their term comes. CLL Gibbs encourages healthy discussion and exchange of ideas among students and provides them a platform to voice out their opinions on current and global issues and explore solutions to various crises. Before moving forward, I would like to present the journal guidelines and working of the virtual debate competition. There will be a draw of lots to decide in order which the teams will be coming up to enter the virtual room to present their debate. During the debate, time left will be shown on the screen at 2 intervals. That is when there is 3 minutes left and when time is over. The total allotted time for each team is 8 minutes. Team shall decide the time limit of speaker 1 and speaker 2, but the minimum time for each speaker is 2 minutes. Speaker 1 will debate for the motion and speaker 2 will debate on against the motion. Suffix A for the motion and suffix B will be for the against the motion. Rebuttals will be including in the 8 minutes given time to each. Team score will be calculated by adding both the team members' individual score. The language of the debate competition shall be English only. Use of web camera or face camera while speaking is mandatory for every participant. Reading from any written document is prohibited. If it is observed by the judges or the organizer, the team will be disqualified. Usage of any abusive or obscene language shall lead immediate disqualification of candidature. CLGIPs shall have sole discretion to assess penalties or to disqualify teams for any failure in abiding any of the foregoing rules. All the team members must refrain from disclosing the identity of their institution at any time or in any manner during the entire competition. Non-compliance with this rule shall result in immediate disqualification of team and decision of CLS GIPs in this regard, which shall be final and binding. Now, as I've done reading the rules and all of the team members know the rules, we will starting the team of draw of lots to know in which team will come. So this is for the session 1, as everyone can see. Round 1. I will be taking the first team out, which will go on first. It's 3NDC 047. It's our first team. 3NDC 047. You at first. You will go on the first. The second team will be 3NDC 004. You will be second team. Third team is 3NDC 0690. Three NDC 069. Three NDC 015 is our fourth team. 3NDC 015. 3NDC 005 as the last team and the fifth team. These are the team for the first session. 3NDC 047, please kindly join. Please raise your hands so that we can let you in. 3NDC047, please raise your hand so we can let you in virtual room. Team 3NDC047, it's a request for you to join right now. Please raise your hand. Moving on with our next team, as I guess they are unable to join right now. Team number 2, that is 3NDC004. Please raise your hand. Team number 3NDC004, please raise your hand so we can let you in. Team number 3NDC004, please raise your hand so we can let you in the virtual room. Team NDC004 has joined.
Am I audible?
Yes, sir, you are audible.
My teammate is having some technical glitch. So would it be fine if you could move on with the next participant and we could rejoin after this? Because she's not being able to join for the last 10 minutes. If it's fine, I mean,
okay,
I've just asked her to join.
Okay.
Thank
So
you so much.
you will be going for the last round then, for the last team.
Okay. So after the other teams are finished, right?
Yes. Please
Thank
let
you
us
so
know
much.
when your partners is here.
Yeah, sure. I'll do that.
Okay, thank you. Going with our third team, that is 3NDC015. Please raise your hand so we can let you in the virtual room. Team 3NDC015. Please raise your hand so we can let you in. They have joined. They will be joining in minutes. Okay. Both the members of the team NDC015 has joined. Please kindly switch on your videos. Both of the members. So you guys are aware of the rules. Okay. And you will be showing slides on the screen that with the times. Okay. So that you are aware of how much time you have left. The team with suffix A is for the motion and the B is for the against the motion. You have ended with your team codes. We may start now.
A very good morning to everyone present here. The House today is concerned with two main questions. One, whether the CA is constitutional or not, and two, what its impact on the minority will be. Today I, Aishani Mukhopadhyay, will be speaking for the CA. Let us begin with the first question regarding the constitutionality. The act has been challenged by many, saying that it is against the constitution as it violates Article 14 that gives us the principle of equality and is a part of the third part of the constitution. To decide whether the CA has actually violated Article 14, we need to consider two key principles. One is the doctrine of reasonable classification, and second is the doctrine of arbitrateness. The doctrine of reasonable classification gives us the provision for permits positive discrimination. That is, discrimination that helps promote equality. So, for example, we can consider the provisions for scholarship for girl child, the Age Discrimination Act of Australia, and obviously our reservation. With the bird's eye view, we can see that the CA does abide by the doctrine as it seeks to provide citizenship to the illegal immigrants who have come into India with an aim of staying here to receive shelter from the persecution back in their home countries. So we can say that the CA does satisfy the doctrine of reasonable classification. This being said, I would also like to mention here that there has been no specification of this extent by any in the Constitution or by any case law. And that is what brings us to the next test, that is the doctrine of test of manifest arbitrariness. This one is a wider test, which requires the legislation to, quoting the Shaira Bano versus Union of India case, conform to norms which are rational, informed with reason, and guided by public interest. This test of manifest arbitrariness involves a determination as to whether something is done capriciously, irrationally, or without adequate determining principle by the legislation. The CA makes a few questionable presumptions. However, they cannot be said to be arbitrary as it does not meet the high threshold required by the test. And again, the extent has not been specified. So with regards to these two tests, we can say that the CA does satisfy the doctrine of reasonable classification with whatever extent we can assume. And because nothing has been specified for the second test, we cannot declare it unconstitutional. I would like to quote Harish Salve here. I fail to understand how a law which is designed to confer the benefit on an identified class of people and which identification is based on a rational criterion can be condemned by discriminatory on the ground that the legislation could have created a wider class, arrived at by applying a broader criterion for identifying the class of those who would benefit by the legislation. Now another reason that the CA has been declared to be unconstitutional by many is because they believe that it violates the Assam Accord. However, it is clearly mentioned in Section 3, Clause 4 of the Act that this shall not be applicable to, quote, the tribal areas of Mizoram, Meghalaya, and Tripura, as included in the 6th schedule to the Constitution and the area covered under the inner line notified under the Bengal Eastern Frontier Regulation. Now that the Constitution has been talked about, let us talk about the second question, the impact on the minority. Before commenting any further, I would like to mention here that no provision states that Indian Muslims will be deported or lose their current citizenship. The CA 2019 aims to extend Indian citizenship towards a certain group of people and not take anyone's citizenship away. Again, another point that I would really like to mention here is that all that the CA does is provide for a speedier process for to the application of Indian citizenship, and it doesn't disqualify anyone from applying for Indian citizenship at all. So Muslim refugees or refugees from any other community can apply for Indian citizenship under the regular process. As I conclude, I would like to say that the CA is a very good step that has been communicated in a bad way and comprehended in an even worse way, leading to chaos and misunderstanding. With this, I rest my case, but certainly not my stance. Thank you and Jai Hind.
Good morning to the very distinguished jurists and my fellow competitors. I would not only like to introduce myself as a person who is striving with her law school syllabus, but also as an responsible citizen of India who's trying to unleash India from the claws of any form of discrimination and so on. And today we are going to discuss the constitutionality of the Citizenship Amendment Act of 2019. The act, is it a violation of Article 14 or is it a threat to the secular nature of the Constitution? Article 14 states, according to my notion, it is a total violation of Article 14 because Article 14 provides equality of rights and protection of rights to each and every citizen within its territory, as well as it prohibits any form of discrimination. But the CAA 2019 is something which infringes the Article 14 of the Constitution by discriminating illegal immigrants on the basis of religion. Coming to the secular nature is something which has been there in the Constitution right from the beginning. The CAA 2019 has infringed the secular nature by discriminating immigrants on the basis of religion. Pakistan, Afghanistan, and Bangladesh are three countries which have declared Islam as their state religion. But according to BBC reports, it has been stated that the non-Muslims there still have their rights and they're allowed to practice their religion in those countries. Whereas there have been cases of Muslim persecution. Whereas the Indian government states that Muslims can never be persecuted in this Muslim majority countries. Let me cite some examples. Coming to the Shia Muslims of Pakistan. The Shia Muslims of Pakistan and Afghanistan make up 15 to 20% of the population. Whereas they have been targeted every now and then with multiple bombings, attacks. There are anti-Shia groups, militants, participants in Pakistan and Afghanistan who are active and they are killing these Shia Muslims. If these Muslims come to refuge in India, will India deny? Coming to the second part, the Indian government had also stated that when Muslims come to India, they do not come out of religious persecution. But the founder of the LGBTQ magazine of Bangladesh had stated that as a persecuted gay Muslim, I was never welcomed in India. He was a survivor of religious violence and he had to leave Bangladesh in 2016, fearing third-party violence, though he was a Sunni Muslim and a majority population then in Bangladesh. But in India, he was never welcome. In his words, the Citizenship Amendment Act of 2019 has reduced the Muslims to a monolith entity where they lose their caste, sex, and all their rights that are available to them. Moving on to the NRC. The CAA 2019 has affected the NRC to a great extent. It is seen that this provision is an echo of Donald Trump's provision in America, where they have broken up families. And this is how they have similarly broken up families in Assam as well. Many Assamese have to be deported.
So sorry, your time is over right now. I request the judges if there are any questions they can ask to the team members.
Not really, except of the fact that they did not get a chance to rebut each other.
Okay. Thank you, team 015, for such an informative debate. You may leave now. Thank you so much. Okay. So our next team is 3NDC 069. Team members of 3NDC 069, please raise your hands so we can let you in. Team members of 3NDC 069. They're in. We will start now. May please switch on your videos. Please switch on your videos. Team number 069, please switch on your videos. They're just entering. Okay, both of them has joined.
Am I audible?
Yes, you are audible.
Yeah, ma'am, it's a humble request. Just a minute, my teammate is joining.
Yes. Okay, your team members joined. Please switch on your videos. NDC 069B, please switch on your videos so we can start. Okay. Your time starts now. Please introduce yourself.
Good morning to the respected judges. One of the most important aspects of human identity is providing identity to oneself. And the power to grant this recognition lies with the state. As popularly asserted by Hannah Arendt, that citizenship is the right to have rights. This is true in today's sense. And I firmly stand here for the motion. Our society follows the principles of utmost equality and individual freedom. Based on this theory of inclusion and denying oppression to these people, the government of India had brought the Citizenship Amendment Act 2019 with an idea to make these oppressed class belonging to the which constitute the minority belonging to the states of Bangladesh, Afghanistan, and Pakistan into the mainstream society. This oppression on base of religion has been done by majority class. And this is the most shocking aspect. It is done blatantly without the fear of a law or authority or an agency. This implies that this might be state-sponsored itself. Religious persecution in these countries are not new today. This has been happening from history, and history is a witness to it. According to a recent report by World Director and Engineers People, it was stated that in the year 1974, Bangladesh overall population accounted for 28% of minorities, which has been reduced to only 8.5% today. Similar is the case with Pakistan, where the minority class in the overall population accounted for almost 23%. Today, they are nearly 1.85%. And similar is the case of Afghanistan, where everybody knows what the radical institutions and non-state actors have been doing. This is a systematic genocide and socialism being done by them. And in fact, the legislature should be commended and congratulated for bringing such a law after many, many years of recognizing such a major demographical problem. The major question to CAA is its constitutional validity. With respect to all aspects, in letter and in spirit, it stands the test of the Constitution. First of all, the major argument against this is Article 14, which talks about providing right to equality or equal protection of law to each and every citizen. This test this fundamental right has to be listed on three major parameters, which has been observed and established. The first is that there should be a logical reason and distinction, which is pertaining to intelligible distinction, and this distinction should have certain nexus with the statute and the object of the statute. This has been established through various judicial pronouncements and is recognized in law. Most pertinent case regarding this is the case of Justice S.R. Tendulkar versus Sri Ramakrishna Dalmia. The Supreme Court in this case had held that the ambit of Article 14 provides for reasonable classification. It does not forbid the legislation from making an enhanceable and a critical intelligible classification for the sake of legislation. It does not forbid it. And this test of the doctrine of reasonable classification, as being quoted by as Apex Court, has been refined in two conventional tests. The very first test of being manifest arbitrariness or perceptile arbitrariness, and second is the logical reasoning or the reasonable classification behind such an exertion. Coming to with respect to both the tests, the Citizenship Amendment Act, it has a twofold classification which is being done to the legislation. The very first, regarding the second test, is a reasonable classification. Here the classification is based on a theocratic nation having a particular state religion and a country which is secular in nature, which does not follow any particular state religion. This itself satisfies the very first question of including those countries, and also regarding the ethnic relationship which we share with these communities, and also the inclusion of equality and fundamental right of individual liberty, which is contained in our constitution, which permits the legislation with this positive intent and the essence of our constitutional framers itself. Coming to the first percentile arbitrariness, this dimension are not defined, but can be quoted on two bases. First, it should be rational in nature, it should be logical, and the most important thing, it should be the larger interest of public at large. The basic tenet of this article of this act is to provide citizenship right to an individual. It does not take away anybody's citizenship right, but provides citizenship right to the persecuted minorities. Here, the classification is done on basis of majority present and minority persecuted. Hence, this Amendment Act follows the principle of 14, and there's no violation of any of such constitutional principles, as even emphasized in Article 15, 21, also 51A, regarding which talks about international relationship. As the global human rights perspective is to provide protection and to the undignified, and the basic end of the Act provides this. The most second important assertion that CAA being discriminatory in nature is itself fallacious and is devoid of legality. Here it has to be mentioned on the basis of what has been done and what cannot be done. I would conclude by stating that by providing these citizenship to these people, we are bringing them to the land of opportunities from islands of isolation and exclusion. And hence with this, I rest my arguments and state that CAA manifestly stands the test of the Constitution and must be welcomed by all the sections of society. Thank you.
The ravages braved by the students of Jamia. The sheer attack on the most basic right of protesting lot of students. The operation faced by the Protestants of Shaheen Bagh. The tireless struggle by the Protestants of Assamese to make their existence count must not go in vain. And therefore, I firmly stand against the motion. Well, I pity the mind of these people who came up with such an unjust piece of regulation, the CAA, Citizenship Amendment Act. So the bill proposes to amend Section 2B of the Citizenship Act, which provides for protection of communities like Hindu, Sikh, Jain, Parsis and Christians from countries like Afghanistan, Pakistan and Bangladesh from the ambit of illegal immigrants. So basically, it creates a regime of citizenship that is stratificated along the religious lines, which violates the inherent idea of secularism or the secular fabric of our very constitution. Furthermore, one of the main contentions raised pertaining to the constitutionality of CAA is the test of Article 14. And this legislative enactment manifestly fails to pass the test of equality, which is the supreme essence of our holy document. CAA is contrary to the values of Constitution. In order to pass this test of equality or this holy embodiment, one needs to satisfy all the parameters of rational classification. Prima facie, it violates the very parameter of intelligible differentia. It includes persecuted minorities. Then why does it not include other communities like Hazaras, Ahmadiyas and Shias who are also persecuted minorities? Why does it not include other neighboring countries like Sri Lanka and Burma? This is because it comes with a preconceived agenda of including only specific of them, manifestly signifying its malified and arbitrary intention. Furthermore, a second point is with regard to the relationship with this enactment. CAA here is too very ambiguous. On one side, it talks about giving protection to the persecuted, but on the same page, it focuses only on few of them. In a nutshell, the CAA Act completely fails to satisfy the parameters of the test of equality, and therefore it is unconstitutional. All I want to say is that this is not an ordinary piece of regulation. This is one of the most arbitrary, unjust, and unacceptable piece of regulation we ever had. I say so because just imagine we have Muslim communities who has been there for 50 years and
I'm so sorry your time is over. Thank you for such an healthy discussion. I request the judges if they have any questions they want to ask, they may.
Just a small query from the team member A as to
Yes,
the
sir.
examples that you have cited with the statistics of persecution in certain areas. Can you please reveal us the source of the statistics?
Yes. So this have been cited from World Directory and Indigenous People. It's an organization which works for.
Thank you.
Thank you.
thank you.
Any other questions, sir?
No, that's all from my.
Okay. Thank you. You may leave the room now.
Thank you.
Now, I would like to request 3NDC005 to raise their hands so we can let them in. Team 3NDC005. Please raise your hand so we can let you in. 008, please enter with your team code. 005A. Team members, please switch on your videos. Both the team members, I may request you, please switch on your video so we can start. Yes, so we have both the team members here. You may introduce before starting for which against the motion or for the motion. Your time starts now.
Respected Chair and all my fellow participants, a very warm good morning to everyone. I, Speaker 1 of Team 3ND-C005, hereby to speak for the motion that is in favor of CAA. 12 December 2019, CAA was duly passed by the Legislature of India. Many questions popped up. Nationwide protests took place. Because Government of India did not expect such a huge protest or such a huge reaction by such a small enforcement. So I think that before actually practicing or actually going to the CAA, we must have a bird's eye to our historical mistake of 1947. This one land was divided on religious basis. About 3 to 4 million people migrated from both sides. But not actually everybody was willing to migrate because somebody drew the line for them. So it was so impossible for them to leave their places or their property. But fortunately, we chose to be secular and the others chose to be the religious republics. That is, they chose to be the theocratic states or the Islamic states. But can you breathe it that by 2017, Hindu marriage was illegal and void in Pakistan? Only 700 Sikhs and Muslims have been left in Afghanistan. Almost all the non-Muslim religious structures have been demolished in these Islamic states. But the argument is India is discriminatory towards a particular community. One thing to be kept in mind is that India is not discriminatory by its laws. Individual discrimination exists everywhere in the world, any society, every nation. But these states are discriminatory by their laws because their laws advocate discrimination. Now the question about the constitutionality of the CAA. My dear friends, Constitution of India is applicable to the citizens of India. CAA has nothing to do with the Indian Muslims or the Indian Hindus. That is, it has nothing to do with the citizens of India. It has specially been focused for the minorities who has been persecuted in the adjacent lands. Moreover, it is not obligatory on the part of the Indian government, either under the CAA or the constitutional law, to have all-encompassing or inclusive policies. Why? Just because of the security reasons. If it is so, then why not to include all the minorities in whole of the world? Just because it all depends from case to case. It was also aired that particular community would lose its citizenship in India. That is the Muslim community. It was wholly misinterpreted and miscommunicated in the population of the India and all the adjacent nations. But my dear friends, we buy mobile phone, we buy SIM cards. At this point, every people of the nation is using the cell phone. And I believe before buying that, we definitely produce some identification document to them. So can you really think or just ask a question to yourself that by having the NRC applicable, anybody will be left out? I think no. If you want to prove your citizenship, if you want to say that India is my country, I will stay here, then prove it by not burning your homes. In the end, I would like to say that CAA is that too little compassion that has come too late. Thank you.
Kirotika, I would like to seek the permission of the judges to proceed with my arguments against Citizenship Amendment Act 2019. सरजमीन हिंद पे कारवाएं अकवाम आलम के कारवां बसते गए हिंदुस्तान बनता गया. So India has long been a land of accommodation and assimilation. India has assimilated all cultures from all over the world, and we have been where we are today, a secular democratic republic nation. The idea of India as structure over the period of time is all inclusive. It is neither exclusive nor discriminatory to a particular class, religion, caste, or creed. It has been enshrined in the Indian ethos as well as in the Indian constitution itself. I would like to structure my argument and substantiate my argument in under three heads. The first being that this Citizenship Amendment Act is per se against the basic fundamental structure of the Constitution. The second argument relates with regard to the definition of religious persecuted minorities, as to who are the religious persecuted minorities, how will you define those minorities, how will you verify that these particular persons or group of community is persecuted in their land. The third argument relates with regard to the cost of CAA when it will be implemented along with the National Register of Citizens, that is NRC and NPR. Now, the question arises with regard to the cost. I would be starting from the cost part, the cost argument, that it will impose direct costs as well as indirect costs. The indirect costs will include the social cost, the economic cost, and the cost that will be incurred by the government itself, and the opportunity cost that will be imposed on the poor tribal people who are not able to produce the documents. They will lose their daily wages to go into litigation to prove that they are the citizen of the country, to produce the documents or whatsoever. The second argument relates to the definition of religious persecuted minorities. As said, there will be 5 particular communities that are included and that will be given the citizenship. Why a particular community has been excluded? Why we have not included the Hazaras, the Ahmadiyas, the religious persecuted minorities in this particular country? Why they have been excluded? And then we have the Rohingyas in Myanmar. Why they have been excluded? That is a question, and this relates to this leads to a fundamental question, that it raises a fundamental question that will religious persecuted minorities also include the communities that are socially as well as economically persecuted? That is a big question, which is that is quite objectionable and debatable. Now, the first argument that I would like to raise is with regard to the constitutionality of the Citizenship Amendment Act. It is in violation per se of Article 14 and Article 15 of the Constitution, as well as Article 13. This to go further into to delve further into the details of this constitutionality, the question of constitutionality, we would like to raise look into Article 11 of the Constitution, which empowers and give power to the Parliament to make provisions with regard to the acquisition of the citizenship as well as termination of the citizenship. And this the scope of this Article 11 of the Constitution has to be read and interpreted in relation to the doctrine of basic structure as laid down in the Kesunanda Bharati, and in relation to Article 368 of the Constitution, which relates to the amendment procedure. Now, we cannot cross the line of constitutional morality and the basic structure, that is secularism, as enshrined by the as held by the Supreme Court in SR Bomai case also, that we cannot cross the line of secularism, we cannot cross the line of basic constitutional structure for amendment of the Constitution, as well as the amendment of any other statutory provision which is deriving the powers from the Constitution itself, that is Article 11. So now the Parliament has made an amendment to the Citizenship Act which is completely arbitrary and discriminatory in its
I'm sorry, your time is over. Thank you for such an amazing performance. I would like to ask that if judges want to ask any question to you.
Again, same question to team member A. You have narrated certain statistics of religious persecution in the adjoining states or nations. Can you please disclose the source of those statistics?
Sir, this source has been confirmed from 2-3 sites, and especially from the articles which have been published in the Hindu and the Indian Express, with all the major parliamentary reports. So this is the source, sir.
Anything on the authenticity of such media reports?
Sir, these are all backed up by the statements of our Union Minister Amit Shah, who has cited all these statistics in the Parliament when this all debate was going on in the Lok Sabha.
Thank you.
So, I would rather more than the question, I would I would rather have a comment on 005 Miss 005A, because I mainly found more of a general perspective, because as it is a legal debate, I would rather give a suggestion to Miss 005A that I was mainly looking for something legal, debate or legal perspective or legal provision which you could emphasize on. Rather, I would appreciate that the examples you gave was fine, but more of emphasis on legal. Thank you so much.
Team number 005, please clear your name as team number 005A, not your personal name, so that the judges are clear while giving you marks. Thank you for your performance. You may leave now.
And also one more thing is just...
Yes, ma'am.
I just had an observation, because you all have to comply with the rules. Make sure you're not speaking in any other language rather than in English. I know it was really relevant there, but please adhere to. No doubt the example and the the proverb you said was opt to the occasion, but please make sure you adhere to the rules. Thank you so much.
Thank you, ma'am. Team members of 005 may leave now. Team number 3NDC047. Please raise your hands. We can let you in. 3NDC047. Please raise your hands. Team number 3NDC047. Please raise your hand so we can let you in. Moving on, we will go for the other team. 3NDC004. Please raise your hands so we can let you in. Team number 3 NDC 004.
Am I audible?
I request team number
Your ID?
004 to switch on their video and audio.
Kindly join through the code which you all are given to you. Kindly join through the number which is given to you rather than with your name, or at least rename it.
Yes, ma'am.
I request you to introduce so that the judges can be clear that who is NDC 004A and who is 004B.
I am NDC 004A. My teammate is NDC 004B. I shall be speaking for the motion, and my teammate shall be speaking against.
Before we start, can I just... Am I audible?
You are totally audible.
Is it fine if we continue?
You're audible, so your time starts now.
All right. Respected panel, on 13th of December 1991, young Mrs. Momal Kohli and her entire family were preparing for her dinner. From the dark of the night, there emerged three men who would firstly ransack their house, and then they took away Mrs. Momal Kohli from the very eyes of her entire family. The next morning, an enraged husband goes to the law enforcement agencies in the land, and he complains about the very fact that his legally wedded wife was taken away from before his eyes. To his utter shock, the law enforcement agencies tell him that the law of the land does not recognize your marriage because your marriage has been done under a legislation which is not recognized by the state. This is the story of Miss Momal Kohli and her entire family from the village of Matari in Pakistan. And this would not have been true had it been from any civilized nation of the world. But this is true because this is a instance of religious persecution happening in Pakistan, Bangladesh, and Afghanistan. And these people have come in from all these countries to India. And the government of India in the year 2020 brought in the Citizenship Amendment Act to protect the people who have been religiously persecuted in all these countries. Now, this legislation has been challenged on three grounds. Firstly, under Article 14, secondly, under Article 21, and thirdly, under the realm of secularism. My submission is this, that it is not violative of Article 14 of the Indian Constitution, because even though the Indian Constitution, even though Article 14 talks about equality, it also gives the government the power to make a classification based on an intelligible differentia. Now, the classification being made here and the nexus that the object of the act seeks to achieve is in clear nexus, and therefore it passes the test of reasonable nexus that the government of India wanted to achieve. The nexus that is being established is because the fact that these people are religiously persecuted in these areas, and therefore a classification is being made to protect these people. Now, the challenge that is being raised is this: why have you not included other countries, and why have you not included the religious minorities of other countries? The legal answer to that is this, that it is a policy decision, and since it is a policy decision, the government gets to decide whom they want to ameliorate and whom they want to do not ameliorate. The second backing that this entire act has is of the policy of non-refoulement. The policy of non-refoulement categorically states that any person who comes from a region where he or she can be persecuted, and they come to a state, the state has the duty to not send back these people to the place from where they came where they had a chance of getting religiously persecuted. Therefore, this entire act is in line with the policy of non-refoulement, which is a international law under Article 38(1)(c) of the ICJ statute. Now, the challenge under secularism is being made, and it is being said that it is going against the secular fabric of the Indian Constitution. Well, first of all, we need to understand that the Supreme Court of India in the S.R. Bommai judgment very categorically went on that in the year 1993 that secularism is a basic structure of the Indian Constitution, and by virtue of the Keshwaran Bharati judgment, no government, be it a right government or be it a left government, can ever go and change the basic structure of the Indian Constitution. Therefore, the secularism remains to be a basic structure of the Indian Constitution. Now this act is being misinformed. The intent of the act is being misinformed to the people, and the problem is this, that the illiterate masses are not understanding what the act actually tries to envisage. It does not deal with doing away the citizenship of the Muslims in India. It merely talks about regulating the status of the people of Bangladesh, Pakistan, and Afghanistan who've come in from these countries. And lastly, I'll end my argument by simply stating this, that there is still a Citizenship Amendment, there is still a Citizenship Act of 1955, which gives power to the government and which provides for the backing for the people who want to come to India and get citizenship if they feel that they want to change their citizenship. Therefore, this entire act is only a gateway that allows certain sections of people, because they have been religiously persecuted, there is data to prove that, and because there is data to prove that, because there is a reasonable nexus being formed by the act, therefore it passes all the tests of constitutionalism. And lastly, and more importantly, the Citizenship Act of 1955 still stands strong. The Citizenship Act of 1955 under various sections, specifically under section 6, allows for naturalization, and since it allows for naturalization, any person from any country of the world can come and reside in India. That is there, and therefore this entire act is not unconstitutional, and it is a very justified act as per the constitution, as well as per the secular aspect of the Indian realm. I'd like to end my speech and would like to hand over the stage for my co-speaker to speak against the motion.
I shall be speaking against the motion, and I shall be establishing before this panel that the Citizenship Amendment Act is not only constitutional but unconstitutional, but also runs against the secular fabric of the Constitution of India. Now, in order for a law to be constitutional, it has to pass the constitutionality test that is enshrined under Article 14 of the Constitution of India, which says that the state has the power to make certain laws for a particular group of people, conferring certain privileges on them. But this law shall be valid as long as it is made on a reasonable classification. Now, classification to be reasonable has to have a direct nexus with the object that the law seeks to achieve. Now, in the instant matter, the objective of the law is to provide citizenship to the migrants who have fled from religious persecution from the countries of Bangladesh, Afghanistan, and Pakistan. A select of 6 religions have been particularly selected who would be eligible to apply for citizenship under this act, namely Hindus, Buddhists, Sikhs, Jains, Christians, and Parsis. Simple and clear words, it has failed to include Muslims. The act clearly leaves out Muslim people who have been religiously persecuted. Now, if the objective of the act was actually to provide citizenship to people who have fled from religious persecution, the act would have involved the act would have included the Ahmadiyyas the Rohingyas of religiously included the Shias and Hazaras of Pakistan and Hazaras of Afghanistan have been religiously persecuted time and again. Now, since the act does not include these groups of people who have been right now mentioned, therefore it clearly makes it evident that the classification does not have a clear nexus with the objective that is being sought by the law, that is to provide citizenship to people who have fled from religious persecution. Now, moreover, since it has failed to comply with the test of constitutionality, it is unconstitutional on the face of it. Moreover, in the case of E.P. Royappa, it was also stated by the court that any law which is arbitrary in nature shall be unconstitutional under Article 14. Now, let us see how arbitrariness seeps in Citizenship Amendment Act. Firstly, the people who are fleeing from religious persecution, how are they may or they may not have enough time to collect all the documents that would identify their religions. So if a person is standing before a foreign tribunal, how is the foreign tribunal going to decide whether the person is in fact a Hindu or belongs to one of the groups which have been favored by the act, or he is in fact a Muslim? Secondly, how is the foreign tribunal going to determine that the person standing before it has been religiously persecuted and that's why he has come to this country, and not because he was looking simply for some opportunities across the border? Sorry, the time's up.
So sorry for the time was over. I would like to request if judges have any questions for the participants.
Not really anything.
Okay. So
Thank you,
maybe
Thank you.
yes.
Thank you.
Team members, please enter only with your team codes, not with your names. You may read now. Okay. So with this, our first session has come to an end. So participants of first session may leave now. I request other participants to enter now.
I think just a clarification.
Yes, ma'am.
Parleen, the team which was not there was
ND 047.
Okay, we are marking them absent. Okay.
Yes, ma'am. Because
this is just a clarification before we enter the marks.
Yes.
Yeah, thank you so much.
Thank you, ma'am. We welcome other team members of the slot 1. Sorry, slot 2. I'm sorry. A very good morning to our respected judges, Mr. Advocate Pravesh Menon and Dr. Anita A. Patil, and to all the participants from various law institutions present here. I, Praveen Kaur, will be the anchor for the day today. Our first judge is Mr. Pravesh, who is yes.
Sir, do you mind them again, introducing us again and again? I feel that is a waste of time because I think we all know each other like right now after the slot 1. So I don't, prefer to waste any more time because we are already 10 minutes late for the second slot. So, sir, would you prefer?
I agree.
Yes. Yes.
Okay.
Sir also agrees with me. So please, can you call the first team? That is the second slot we can begin.
Okay. Okay, ma'am. Thank you, ma'am, and thank you, sir. I will just repeat the rules. So the basic rule for all the participants is that while they are speaking, their videos should be visible, and there will be 8 minutes allotted to all of the teams. Ma'am, sorry to interfere, but we have to introduce this again because we have given team members different times and slots and links, so they don't exactly know. So we have to.
Whatever is required, you please do. Whatever is, I think it is a repetition, you can skip because we are running short of time. Yeah.
Yeah. So I have to introduce you again.
Yeah.
So. Okay.
Just be very precise. You just need to tell us the designation. You don't have to read an entire one para note or the entire page. Not required.
Okay. So our first judge is Advocate Pravesh. He is a senior partner at MZ Legal. He chairs MZ Criminal Litigation and White Collar and Regulatory Defense. He has over 20 years of niche experience in trial and appellate work before national and international fields of fraud, financial, and money. Whereas we have our second judge as Dr. Anita A. Patil. She is an associate professor at Law with Ramia College of Law, RLC, in Bangalore. She has done Masters in Law 2012 from Karnataka University, Dharwad, with 2 gold medals in specialization of business and trade law. She has completed her PhD on social and critical study of legal framework of containing misleading advertisement in India, with special reference of food, drugs, and cosmetics. In June 2016, she is also qualified as accredited mediator in negotiation and mediation. We welcome you, ma'am. A special thanks to respected judges for staying their time. Going further, the rules for the debate competition is that during debate, time left will be shown on the screen with 2 slots, that is 3 minutes and time over. The time allotted for each team is 8 minutes. Team shall decide the time limit of the speaker 1 and speaker 2. The minimum limit of speaker is 2 minutes. Speaker 1 will debate for the motion and Speaker 2 will debate against the motion. Suffix A with for the motion and suffix P for against the motion. Rebuttal rounds will be included in 8 minutes given to each team. Team score will be calculated by adding both the team members' individual score. The language for debate competition shall be English only. Use of web camera and face camera while speaking is mandatory for every participant. Reading from any written document is prohibited. If it is observed by the judges or organizers, the team will be disqualified. Use of any abuse or obscene language shall lead to immediate disqualification of candidate. CLA shall have sole discretion of disqualifying the members if not follow the rules. All team members must refrain from disclosing their identity of their institution at any time and in any manner during the entire competition. Non-compliance with this rule shall result in immediate disqualification. Now moving forward to debate session, I would like to start with draw of lots. It's room 1, session 2. Starting now. So our first team is 3NDC 021. 3NDC 021 would be our first team. 3NDC 009, our second team. 3NDC 009, our second team. 3NDC 008, our third team. 3NDC 008. 3NDC 010, our fourth team. 3NDC 010. 3NDC 034, our fifth team. 3NDC 034. I would like to call our first team, 3NDC 021. Team members of this team may raise their hand so we can let them in. Please raise your hands. Team number 3, NDC 021. team member.
Greetings to the judges.
Please switch on your videos.
Second. Greetings to the judges.
Yeah. Where's your other team member?
I'm just calling him.
Yeah, please confirm.
He's on his way.
Yes, you may start now.
Shall I begin? Greetings to the House. This is Speaker 1, and it shall be dealing with the questions that have been raised against the Citizenship Amendment Act of 2019. Hereinafter, it shall be deemed as CAA. The first and foremost argument, that is the prima facie argument, that is whether that the CAA has been declared as discriminatory and in violation of Article 13, 14, 15 of the Constitution, because it does not involve a specific religion, that is Islam. To counter that, it shall be noted that Section 2 ensures that it is a safeguard to the 6 specific religions which have been facing persecution in these 3 distinct countries that are based upon non-secularist principle and have a state religion of their own, that is Islam. Therefore, it shall be noted that Muslims residing in these countries shall have a much higher stake and in conferring rights, and have a better experience in excuse me, and have a much better experiences in having a secure and a persecution-free of living atmosphere. Moreover, the classification that is based upon the 6 religions is totally based upon the ambits of rational access and intelligible differentia, thereby making it a reasonable classification. Moreover, critics might therefore it means that it is not discriminatory in nature and it is not in contravention of Article 15 and 14 of the Indian Constitution. Moreover, people might impugn now that why did not communities like Ahmadiyya Muslims have been taken into consideration when they were actually facing persecution in countries like Afghanistan and Pakistan. To counter the same, it shall be noted that the Ahmadiyya Muslims have been facing the persecution with the activities that has been on the activities of terrorism and vandalism that has been going on through individual capacity and not by the direct or any indirect instrumentalization of the function of the state. Moving on to that might be some critics, other arguments. Some critics believe that there is a constant threat of physical cross-border immigration and procuring of citizenship. However, Section 2 negates the possibility by conferring the citizenship right to the refugees or immigrants who have been residing in India on or before December 31st, 2014. Moreover, it is an extension of the helping hand to these refugees or illegal immigrants who have been facing persecution for a long period of time, even in India. The same ideology was used in Project Insaniyat with Rohingya Muslims by the present government. Also, to facilitate it, now the 11 years barrier has been actually dropped down to 5 years to facilitate their well-being. Now, moreover, the same argument can be used for countering the counter allegation against the government for increasing their vote banks, as there is no such connection established over here. Moreover, NRC is being linked with the CAA, and it is to be noted that in Assam, NRC had a bad reputation as 1.9 million people were left out of the purview of citizenship. Now, CA guarantees that conferring these rights to these people and thereby negating the bad effects that might happen in NRC. Last, in the final argument, that is the crux of the debate debate, that is whether this excuse me, whether this implementation is in contravention of secularist principle of the Indian Constitution. Then for that it shall be noted that secularism means that there is a separation of state and the religion. However, in the Indian context, it shall be noted that secularism simply means that the state does not have a religion of its own, and moreover, the state shall be very neutral in its conduct to all such religions. Moreover, the reasonable classification as argued above, coupled with the retrospective effect of that applies to December 31st, 2014, that applies before December 31st, 2014, makes it a very secular way of conferring rights towards this citizenship. Moreover, it does not violate any secularist principle, any ideology of the constitutional thinkers. Moreover, it is not in contravention of Article 13, that is, any law which is in contravention of fundamental rights shall be declared as void. Moreover, it can be said that no such articles have been harmed, along with Article 14 and 15 of the Indian Constitution, and this very act is a very much valid and a very much needed law. I hereby submit my submission, and if there are any questions, I'm happy to take.
Team B, you may start.
Sir, am I audible?
Yes.
Greetings to the House. The Citizenship Amendment Act, passed by the Indian Parliament in 2019, may not seem divisive at the face of it. However, when combined with the National Register of Citizens, it could become the greatest act of social poisoning by a government in independent India. If the Assam model of the NRC is implemented nationally, citizens will require documents such as electoral rolls from up to 1971, land and tenancy records, citizenship certificates, residential certificates, and many more similar documents. However, as pointed out by Delhi Chief Minister Arvind Kejriwal, 70% of Indians will not be able to provide these documents necessary for citizenship. This is especially relevant in the case of homeless citizens and victims of natural disasters. In the state of Assam, the NRC declared Muslim former army officer and Kargil war veteran as a foreigner, sent him to detention camps simply because he could not submit these necessary documents given in the list. The NRC process has been conceived in a manner that spares Hindus, Christians, Sikhs, Buddhists, Jains, and Parsis from the trouble of providing these documents, because the CAA eventually offers a pathway of Indian citizenship for all these religious groups. Those declared as non-citizens, however, be moved to detention camps or live the rest of their lives as stateless citizens. Muslims are not mentioned in this list. We're stripping them of their fundamental and voting rights. Potentially, millions of Muslims will end up, even Muslims who are rightful Indian citizens will end up going to refugee detention camps simply because they cannot provide these documents. So is it actually ethical for Indian law to have different implications for residents belonging to different religious groups? CAA supporters, they constantly argue that this act was intended to safeguard the rights of religiously persecuted minorities from three nations, that is Pakistan, Afghanistan, and Bangladesh. This is based on the very flawed assumption that Muslims cannot face any form of religious persecution in these three nations. Because statistics show that Ahmadiyas, Shia Muslims, and ex-Muslim atheists all face much religious persecution in these three states. Yet, they will not enjoy any refuge in India because of the CAA, because on paper, they are still shown as Muslims. And if the CAA was truly meant to protect the persecuted groups,
you may stop now. Your time is over. I would like to request judges to ask any question if they have to for the participants.
Not from my side.
Okay. Ma'am, you're not audible.
We don't have, Parvi.
Okay. So, thank you for your performance. You may leave now. Team members of 0 to 1. Thank you.
Thank you, judges.
Thank you, judges, for your time. It's been pleasure submitting our arguments before you.
I would like to request team number 3NDC009 to raise their hand so that we can let them in the virtual debate room. Team number 3NDC009. Team number 3NDC009. Please raise your hands. Team number 3NDC. Please, team number 009, please introduce yourself.
Good morning.
Please switch on your videos, both the team members. Team number. Okay. You may introduce yourself as you're not with your team coach, so judges may be confused. So please introduce yourself and you may continue.
Good morning, judges and my respected fellow participants. I am from team number 3ND009 and I am speaker 3ND009A and I will start now. Respected judges, speakers and my fellow participants, I am speaker A and from the team 3ND009A and I would be speaking my viewpoints for the motion on the given topic. Hereby I commence by saying, those of our brethren separated from us due to political boundaries, watching us that due to political reasons and due to political opponents cannot join us in our celebration, we are also concerned about them. Whenever they want to come into India and be a participant of our happiness, they are always welcome. And thereby I uncle. These were the words given in the first speech given by our very own omnipotent and efficacious First Prime Minister Jawaharlal Nehru. Further, I would like to draw the attention of the judges and my fellow participants to the fact that when the government of India in 2019 enacted the Constitutional Amendment Act, Citizenship Amendment Act, it was apparently initiated that the CAA is firstly not applicable, that the CAA is not firstly applicable to the citizens of India, and secondly, that it doesn't obscure citizenship status from any citizen of India who is presently who has presently obtained the citizenship. Hence, it is not violative of the fundamental rights, Articles 14, 21, and 25, which have been enshrined in the Magna Carta of the Constitution of India. Further, it is exclusively administered and implemented that on 6 religious groups, which have been ridiculed, tormented, and persecuted based on their religious and beliefs, in the 3 neighboring countries have been tabulated as religiously persecuted groups, mainly Afghanistan, Bangladesh, and precise Pakistan. These 3 nations have topped the charts in ridiculing and tormenting these 3 religious classes, for instance, Hindus, Sikhs, Jains, Buddhists, Parsis, and Christians, and they have been mercilessly subjected to be suffering pain and agony, and hence have been ridiculed time and over again, and thus violating the pact signed signed in the year 1950, which is promoted as the Nehru-Liaquat Pact, which is coherently authorized both the governments of India and Pakistan to ensure mandatory release, their protection and safeguards of the minority classes which are being residing in India and Pakistan. The aspiration of the CAA is glorious, and it is for the inviolability of the minorities and to ensure blanket citizenship, to render them a blanket citizenship for their safeguards. I firmly corroborate the credentials of the CAA, which is indeed based on the doctrine of reasonable classification enshrined in Article 14 of the Constitution, that is right to equity. It has been accumulatively outlined the essence of the doctrine. Further, the purpose of this act is a constructive method to ensure the safeguards of the minority, and it shall be seen as a reformative step for the religiously persecuted minority groups who have spent most of their lives in pain and agony. The CAA should be taken as a calculated measure and a safeguard, and also a pedagogical measure that enshrines humanity and mankind and the essence with the essence of the principles of natural justice. And to conclude, I quote the thoughts of Rajendra Prasad that we are eager to welcome the minority groups that are residing in pain and agony in the neighboring countries. And I unquote. This thing ultimately can ultimately be like a learning for us and the new generation, which thus reflects the cultural ethos and the values of our Indian society, quoting Basidev Kutumbam. And I answer. Thank you.
Greeting to all present here. I am going to speak against the motion. So basically, the contentious Citizenship Amendment Act 2019, which is also referred to as CAA, is not only discriminatory but also against the foundational philosophy of the Indian Constitution. The act is enacted to target the India's largest minority community. Under the Principal Act, of the Citizenship Act 1955, there are 5 ways of granting citizenship, that is by birth, by registration, by descent, by naturalization, and by incorporation of some territory into the territory of India. And also under the Act, under Section 2, Clause B, the definition of illegal immigrant has been given, under which any person who has the entered into the territory of India without a valid passport or visa or any of the document, or entered into the territory of India without valid passport or visa, and which has been rescinded due to some reasons, will be considered as illegal immigrants. So shockingly, CAA has granted citizenship on the basis of religion and also has changed the definition of illegal immigrants. Under this, they have granted citizenship on the basis of religion. So under this, they have excluded from the ambit of one particular community, that is Muslim. And further, they have also excluded the ambit of protection, in which the requirement of 11 years is been reduced to 5 years. They have granted the citizenship to the minority of this 6 community, that is Hindu, Sikhs, Buddhist, Christian, Parsis, and Jains of Bangladesh, Afghanistan, and Pakistan. And here the religion cannot be a factor for the acquisition of citizenship, because the principle of citizenship that was accepted by our Indian Constitution was based on civic nationalism and not on religious as a factor for grant of the citizenship. Thus, it hits the preamble, and where the secularism is its basic ingredient, and it also hits Article 40, which provide equality before law and equal protection of law. Further, it also hits Article 15, Article 25, 29, and 30. Beside that, Article 51C and Article 253, in which our country is under obligation to respect international agreement also. Article 14, Article 11 of the Parliament, though provides authority to Parliament to amend the law, but the Parliament cannot amend the basic structure of the Constitution itself, and that cannot be amended by amending the Constitution itself. So this was held under Keshwananda Bharti case. And further, I would like to add under this that CAA, which is just an ordinary law, cannot change the basic structure of our Constitution. Further, it also violates Article 9, and which provide that no person shall be provided the citizenship by virtue of Article 5, and shall be the citizen of India by virtue of Article 6 and 8, because the citizenship cannot be granted to the person who has already acquired a foreign citizenship. So on whatever ground they are giving the citizenship to these people, they have voluntarily acquired the citizenship under in these countries, Bangladesh, Afghanistan, and Pakistan. Thank you.
Any questions from the judges for the participants?
No.
Thank you for your performance. You may leave now. This was team number 3 NDC 009.
Parveen, make sure that these they are joining from the code, because I can see still their names.
Yes, ma'am.
Sneha Goswami, and I think they have to adhere to the rules and regulations also, right?
Yes, ma'am. We have already told them this, and still they are doing this. That's why I've told them that to introduce
because that
them.
is also one of the ground for disqualification. That has to be made sure they know that, right?
Please, all the team members, please enter with your team code. It's very difficult to allot your marks and to differentiate. Please enter with your team codes. Now, team number 3 NDC 008. Please raise your hands. Team number 3 NDC 008. Team number 3 NDC 008. Team
Hello.
Yeah, please switch on your videos.
Am I visible?
Yes, please change your name, introduce yourself as a team code, and introduce.
Before I begin, I actually joined from the email which was sent to me, and there was no option to change my name. I do know that I have to enter through the team code that has been given to me, but it did not give me an option to change into that. It just directly logged me into the room.
Okay. One second.
So if I have to rejoin, I can rejoin with the team code itself, but it is not giving me an option to do
Okay,
so.
just please introduce yourself as a team code and from which side you are, so it's easier for our judges.
Okay,
And
I am DNC 008B. I will be against the motion. My teammate will be DNC 008A, and she will be for the motion.
your partner is not able to enter the room. Can you confirm? Tell her just to enter the room.
Okay, just give me a second, please. I have texted her and she will be here in a minute.
Okay.
Would it be okay if she starts first?
Yeah, not a
She's
problem.
supposed to start first. She's supposed to start first.
Yes, ma'am. She is saying that it says your testing was not done. Is that a problem?
Oh yeah, I think so. Tell her to enter room and first she has to test the audio, right? Tell her to
Okay.
test that audio so that she is confirmed that her she is able to hear us and we are able to hear her, right? So tell her to re-enter the
Just a
room.
second, please. It is saying that she is saying that she has been trying to complete the test, but it keeps on redirecting her to the home page.
Parveen, can you just schedule them at the end?
Yeah.
Sorry, we are wasting a lot of time now. Please
we will-
schedule them at the
Yeah,
end.
okay, ma'am.
We will schedule
We'll
at
go
the
to the
end.
end.
Yeah. I will tell someone to call you from our side and
Sure.
resolve your dispute. Okay.
Thank you. Thank you.
Yeah. So for the next team, it's team number 3, NDC 010. Team number 3, NDC 010. Please raise your hands. Team number 3, NDC 010. Team number 3, NDC 010. Please raise your hands. Moving on. For team number 3, NDC 034. Team number 3, NDC 034. Please raise your hands so we can let you in. Team number 3, NDC 034. Kindly raise your hands. Okay, now may I request, please, 3 NDC 008, please enter. Please raise your hand. Team number 3, NDC 008. Team number 3, NDC 008. Please raise your hand so we can let you enter.
Parveen, who's Anjana Kameshwar? They are keeping messaging constantly asking that they're not able to join. I don't know which code are they referring to, which code are they representing. They are saying that they are facing some issues. Kindly accept my request. I don't know which code is that.
Ma'am,
Just see your chat options.
yeah, ma'am. I will just clear it one. So our team member 008 are joining. Team number 008, please raise your hand. We have accepted your request. Please raise your hand so we can let you in. Okay, so I will once again announce for the next different teams. Team number 101, 3NDC 101. Please raise your hand.
Praveen, it is 010.
Okay. Team number 304, 3NDC 0304. Please raise your hand so we can let you in. Moving further, I will once again repeat team number 008. Team number 008. No, you're not audible.
Hello, am I audible?
Yes, you are. Yeah. Yes.
Hello.
Yes, you're audible. Please, both of the team members, please switch on your videos.
Hello. Am I audible now?
Yes. You guys may introduce yourself.
Just 1 second, if I can just finish the settings. Yeah, there's also a request to Parleen. Can you please let us know when we finished 4 minutes so we can switch the speaker? Is that okay?
I'm sorry, the rules have already been announced that there will be two slides present to you with three minutes left and one time over. It's in the rules.
Okay.
You guys start now. Start.
Yeah, I'm just introducing. I am speaker number 1, NDC 008A, and I will be speaking for the motion. The Citizenship Amendment Act 2019 that was passed in an amendment to the 1955 Act provided a pathway to Indian citizenship for illegal migrants from Afghanistan, Bangladesh, and Pakistan who are Hindus, Sikhs, Buddhists, Jains, Parsis, or Christians and arrived in India.
Just a second. Are you reading from somewhere from your desktop?
No, I'm using my laptop and I don't have glasses actually, so I'm having to bend.
No, please make sure you're not reading it from somewhere.
No, ma'am, I just have a laptop to present.
Yeah, carry on.
Okay. Hello. Am I audible, ma'am?
Yeah.
Yeah. Okay. So this Citizenship Act 2019 has undoubtedly driven a deep chasm in between a lot of people in the heart, not only in the heart of Indian polity, but also in the society as well. And although there have been many pleas challenging this particular amendment in the Supreme Court of India, the enthusiasm has spilled over the streets. Under Article 246 of the Indian Constitution, the Parliament has got an exclusive power to make laws with respect to any matters listed in the list 1 of the 7th schedule, item clause number 17, with respect to citizenship and naturalization of aliens. Therefore, only Parliament has gotten the powers to legislate the citizenship. There are 4 concepts that we should know. One is the CAA, the NRC, the NPR, and the census. Census, as we all know, is a 10-year estimation of number of citizens residing in a country. However, the only issue under Census Act is that this particular the census records is usually not for public record and also does not help the government utilize it for public uses. However, under NPR, it is basically a registry of the people residing in India and not just citizens. So this number, this estimation is going to help in making public policy for the public welfare. It has also been guaranteed. There is also a concept for National ID Card of 2003, which is guaranteed under Citizenship Act, which is under Rule 4 subclause 3, which helps this particular NPR make it available in the public forum to make it better for public welfare uses. So the primary ground on which the CA is being challenged is the ostensible violation of the Article 14 that is enshrined in our Indian Constitution that provides with equality before law and equal protection before law. However, in the cases of D.S. Nakar versus Union of India, Deepak Sibal versus Punjab University, and several other cases, the apex court themselves have given judgment that in case there is a reasonable classification that meets the doctrine of intelligible differentia and the rational nexus, then this particular reasonable classification is enough to make a particular legislation valid, which is in the present case, as all the persecuted victims of Bangladesh, Afghanistan, and Pakistan, whether it be Jains, Sikhs, Christians, Parsis, or Hindus, will be covered under the reasonable legislation. Moving forward, the most crucial factor to any that would belie on any challenge of any constitutional validity of any act for that matter is that if it pertains to aliens, rather than citizens, and second, the exclusive power to register vis-a-vis foreign jurisdiction, citizenship, and naturalization, which I don't see how is an issue, as Section 5, subsection 1, subsection A guarantees for registration, and Section 6 guarantees for naturalization. And for this purpose, the third schedule of 1955 Act has also been amended to reduce the residence requirement from 11 years to 5 years, and it simply means that it is giving a particular kind of relaxation to all kind of minorities. Now, moving forward, if we consider the concept of aliens as such, the whole concept of it meeting the doctrine of intelligible differentia and rational nexus, to one point even subsides because Article 14 itself covers aliens under persons. So we don't need anything specific that is required to defend this particular concept. However, are we trying to grant citizenship to people, or are we trying to take away citizenship from people who have valid citizenship? No. All we're trying to do is streamline this particular process. If you look at countries such as Afghanistan, the JPC report, that is the Joint Parliamentary Committee report on the Citizenship Amendment Bill, has given out statistics where a lot of people in Afghanistan, initially there were almost 6 to 7 lakh minorities. However, only 500 are left now, and all these people have fled to India with a fear that they will be religiously persecuted somewhere else. One thing that people usually don't talk about is the Article 25 that we're still allowing people, irrespective of whether you're an illegal immigrant or not, any person residing in India has that right to freely profess, propagate, or preach their religion. It is why one of the major reasons why people even flee to India, because of this particular right being granted to them. In conclusion, I'd also like to bring to notice that the Nehru-Liaquat Pact of 1950 that was signed on April 14th of 1950 points about, between India and Pakistan, points out about how they wanted to protect religious minorities. However, in light of the recent incessant persecutions that have been happening in various countries, I think that obligation also lies on India to protect. If you look, CA 2019, I think draws back its origin to this particular pact. Also, if we're talking about protection, we are granting protection. We are giving them the protection of individual asylum or personal protection is not taken away. So if you ask me, the polarization of concept between religions and caste has been as ancient as the concept of developing into modern India. However, there has been a lot of controversies and a lot of against opposition to it. It is why it is making it a fertile ground for protest. But the truth should not be bent down just in the name of a good story. So I'd just like to pass on to my teammate. Thank you.
May I begin?
Yes.
Good morning, everyone. I am Gurpratap Singh, and I will be speaking against the motion, and I will be discussing the topic, whether the CAA is against secularism or not. Very firstly, it is given in the preamble of a constitution that India is a secular nation. What that really means is that Indian government cannot interfere with religion, neither the growth or not deter it. Now, religion has a deeper meaning. It is not simply limited to whoever you worship, but rather the community, the culture, the tradition aspect as well. And the topic that I'm going to cover is the demographic threat which the Northeastern community particularly faces due to the CAA, as the amendment of CAA will change the demographics so vastly that the population itself in the Northeast will become the minority after citizenship is granted to the immigrants over there. Now, such a demographical change, you may simply say, oh, well, they can simply coexist. Well, let me give you the example of Palestine. During the time of World War II, when Hitler was on a killing spree of the Jews, the United States decided to give shelter to the Jews in Palestine, which was initially a Muslim population. If you look at it now, 100% of the population has been displaced almost, and it is mostly a Jewish nation. There were civil wars, there were terrorist activities, organizations, and essentially the Muslims were kicked out of their own home. And now you'll say, oh, it can't happen in India. It is my beloved India. We are not at war or anything. Well, let me give you the example of Kashmir and how demography really matters to a community. During the time of Mr. Jawaharlal Nehru, when the issue came to light for the very first time in the United Nations, the discussion was to conduct plebiscite, which essentially means to conduct voting with regard to the population regarding which country do they want to join. At that time, if plebiscite was conducted, it would have gone in favor of Pakistan. But Russia, being a good ally, did veto and hoping that the demograph changes eventually. And at some time, if plebiscite had to be conducted later, it will favor India. And that is why demograph is such a huge important factor, and the CAA technically changes it for the Northeastern community, and which is kind of a shame because the Northeastern community has been a very historically rich It is, in fact, one of the only community who was unconquered during the 200-year-old reign during the Britishers, and the Axum tribes who successfully defended it has been living there for over 300 years now. And if we compare it to the Kashmir situation, we all know how peaceful Kashmir really was throughout the years. Thank you very much.
Ma'am, can you give us an extra second for rebuttal or something?
No, I'm so sorry. The rules doesn't allow that. You were well aware of the rules. Thank you so much for your performance.
You.
I would like to ask if the judges want to ask any question to you, to the participants.
I would like to ask, that is mainly 008A.
Yes, ma'am.
What exactly was the Nehru-Ling Pact of 1950?
1950, the Nehru-Liaquat Pact that was signed on 14th April of 1950 was basically between India and Pakistan to protect the religious minorities between both the nations. However, because later on Pakistan had dwelled into incessant amount of religious persecutions, which is why in my argument I have talked about how at least the obligation lies still on India to honor that pact.
Yeah, but at the same time, are you aware of what exactly the minorities' rights were being taken care in the Indira Mujid Pact of 1972? Are you aware of that? And what exactly, how many refugees have been taken care of within India?
Yes, ma'am, I read a brief about Indira Mujid Pact. I am not completely aware of that. However, I just wanted to point out in my argument that the CA 2019, I think, has its traces back to this particular pact, which is why I wanted to give you a small line on that. That's it.
Thank you so much.
Thank you, ma'am.
Any question from your sir?
No, thanks.
Okay.
Thank you.
Thank you for the team members of 008. You may leave now. I would request 3NDC010 to raise their hand. 3NDC010. If they are here, please raise your hand so we can let you enter. NDC010. Okay, moving on to the next team. 3NDC034. Please raise your hands. Team number 3NDC034. Team number, okay, there. Please switch on your webcam.
Am I audible and visible?
Yes, you're audible and you're visible. Where's your teammate?
She'll be joining shortly.
Okay.
If you don't mind, can I just check her status if she is able to join? Yeah, she joined.
Yeah, please introduce yourself as your team code. Please switch on your web cameras. Both of you need to switch on your cameras while speaking and while presenting. And please introduce yourself as your team code so that it will be easy for our judges to mark you. And you may start now. Yes?
Yeah, I'm sorry.
You may continue.
I am Team 3NDC034A and I'll be speaking for the motion.
Yeah. Okay. Your time will start now. Both of you.
A very good afternoon to all the dignitaries present over here and my dear opponents in the virtual room. Citizenship Amendment Law. Is it constitutionally valid or a threat to secular nature of the Constitution? Well, my answer for this is yes, it is constitutionally valid and is not a threat to the secular nature of the Constitution because of the following reasons. First, the term secularism was introduced by the 42nd Amendment in 1976. I believe the very first preamble of our Constitution, the very first phrase of our preamble, which is "We the people of India," is itself secular, as it states the people of India and not the people of any other religion or any other state. The term secularism in the preamble, the term secularism is mentioned in the preamble, and hence it is non-justiciable. My first clarification about the CAL is it gives citizenship to the illegal immigrants and it does not snatch away any rights of any citizen, be it to any community. Second, this act does not violate Article 14 of the Constitution, which is equality before law and equal protection law, as it permits reasonable classification. Here, the reasonable classification by the CAL is scrutinized on the basis of 6 minority religious communities, namely Buddhism, Christian, Hindu, Jain, Sikh, Parsi, from the 3 majority Islamic countries, which is Bangladesh, Pakistan, and Afghanistan, to bring the unequals to the equals. For example, in our India, the reservation category, which is the reservation which is provided to the socially and economical backward category, is also a method and is done on the basis of religion to make the unequals to that of the general category equal. So I think if nation could be divided on the basis of religion, and if the nation can be divided on the basis of religion, then why not citizenship should be granted on the basis of religion? Now, many of you will ask, why not Muslim minorities be given the citizenship? Because I think the states which are, the countries which are mentioned are especially the Islamic majority countries. And if you see, when it comes to come the Indian minority citizenship in their nation, I can guarantee that these nations, the nations mentioned above, will not be interested to grant citizenship. Now, the third point is about the Sri Lankan Tamils and the Rohingyas in Myanmar. I would like to divide it into 2 parts. First, the Sri Lankan Tamil traders from India that went to Sri Lanka during the British rule. And they were the most benefited community due to the cross-border trade, and the Sinhalas were the deprived. Later, the end of British rule turned the sides, and the Sinhalas were in a power dominating the Tamilians. When I look at the history, what I see is the war which was started and the persecution which led was more of power-oriented than religious and cultural. When it comes to Myanmar and the Rohingyas, the International Court of Justice made it clear that the population, the Myanmar government and the authorities must take care of the Rohingya population from genocide. What I believe is Myanmar, Sri Lanka, may it be any nation or their respective governments, India is not responsible for the protection of any other nation's affairs or their nation tasks. What I see is, as said by Mr. Rabindranath Tagore, I quote, India was and is a very powerful magnet for the worst of traders, the worst of traders, the intruders, the majority of migrants, immigrants, refugees, and the greediest of traders. And the tradition continues. What I believe is the CAL is the barricade to stop the above tradition, and and is the correction of the Nehru Treaty in Delhi 1950. That's all. Thank you.
I think the next.
Request my next participant to speak.
Shall I start?
Yes.
Okay. A very good afternoon to respected judges. Today we are discussing the constitutionality of CAA, and I'll be speaking against the motion. Now let me start with the flashback. There was a time when there were uncertainties in the world, and new nations were being formed, and countries were celebrating newly gained independence. And India was one of them. And a fact that we must still take pride in is that India chose to be a democracy, but sometimes I feel this democracy of ours is in shambles. When our preamble explicitly claims that we are a secular nation, how can we adapt to laws that blatantly discriminate on the basis of religion? On 10th of January 2020, a law came into force in India that was robust enough to question the very principles on which our constitution stands. The law I'm talking about is the Citizenship Amendment Act that makes it easier for a particular set of people to get citizenship in India on an irrational basis, which finds no reasonable nexus, also citing a particular date as cutoff. Now, in a country of 138 crore people, at a stage where we find it difficult to sustain our own people, where the evidence from the Global Hunger Index says that India has extreme hunger levels, at a time when our health infrastructure has already been exposed in this pandemic, and where for every single job vacancy, thousands and lakhs of people apply, at a stage where we are not able to sustain our own people, how can we think of accommodating even more people? Will that not amount to snatching away the basic rights of the citizens? And anything that snatches away the rights of citizens cannot cannot pass the test of constitutionality. Now, nothing sounds as vague and unreasonable as saying that Muslims are unlikely to face persecution in their homelands. What makes you think that all Muslims are treated well in their homelands when the data shows that even many Muslim communities like the Ahmadiyyas and the Shias face discrimination in their homelands? And if the sole purpose of this act was to provide relief to the persecuted people, why not include these Muslims as well? This act is a plethora of ambiguities because, first of all, what about people who initially belonged to these 6 communities but were forced to convert to Islam? Will this persecution make them ineligible to get the benefits of this act? And if it is so, then this renders the very purpose of this act as worthless. Also, what about people who convert into Islam after getting citizenship? Will this act then survive the test of Article 25? Also, what's the reasonable nexus behind choosing this particular date? Who gets to decide which date should be used as the cutoff? All of this makes us to think that there's something wrong with this act. Thank you.
Yes, thank you for your performance. It was a great, informative debate. I would like to ask judges if they have any other questions for the participants.
I would like Ms. 034A, as you spoke about a historical aspect of the entire scenario, when exactly did the start of migration happen and what did the government promise with regard to NCR long back in 1999, as you spoke about the historical background of this?
Ma'am, what I spoke about was during the British era and not the 1999. It was approximately to the 1985 period, and there was the NRC thing was not related to this.
No, I'm asking you since the beginning, like 1920 also, when exactly this started happening and when the special status of Assam was mainly, started. The beginning of the migration from the Bengal to the northeast mainly happened. And what exactly did the agitation happen due to which we have so much of ruckus after this amendment came?
Yes, ma'am, surely. Ma'am, this was happened because because as we have seen, Assam was the provincial of Bengal, and that time there were major settlements, and even in the letter to eradicate the settlements over there, which was illegal, the Assam Accord was signed. And this Assam Accord, which was the cutoff date 25th March 1971, if I'm not wrong, this CAA takes this cutoff date to 31st December 2014. So it is basically the agitations which was going on for 6 years. The agitation which was going on for 6 years is the correction, is the extension of the date. So it is basically profitable to those people who were migrated from the Afghanistan, Pakistan, and Bangladesh, and who were settled, and those who were especially belonging to major terrorist groups will help to get vanished from these states. And I think what comes first is the welfare of the nation. Giving citizenship to those who can be a threat to our nation can be a little unfair. That's what I think.
Exactly. The government had mainly promised that they would be deported back, right? But did your government do
sure,
so?
Ma'am.
Did your government do so?
Ma'am, as far as I know, the Rajiv Gandhi, when the Mr. Rajiv Gandhi signed, Mr. Rajiv Gandhi signed with the All Assam Students Union, they were deported. I do not know, I'm not aware of the exact number. Sorry for the lack of information, but there were deportation, and I believe when the Supreme Court ruling in 2013 made it clear that there should be construction of roads, there should be barbed wires near the boundaries, so as there should not be any intrusion and deportation illegal. There was steps taken. But as we can see, still there are many secret ways through which this intrusion carries, and I guess this act can correct that loopholes. So it is constitutionally valid, and as far as the Assam is concerned, there is inner permit line. This act will not apply to Assam, Meghalaya, Tripura, and the Assamese are safe. They do not need to worry. The tribals are safe. So this is
when you say the inner permit, which are mainly the tribals which are coming under the inner permit?
Ma'am, the Bohas are the Dohas. I guess the Bohas are also tribes that comes under inner permit, and the western side of the Assam also comes in the inner permit line.
Is Manipuri also coming under the inner permit?
Yes, ma'am. The Manipur, Tripura, this act will not apply to that area. So this states need not to be aware, and NRC was also first carried out in these states. There were detection of illegal migrants, and obviously the people who led to terrorism. So I guess it is very fair for the government to exclude these states from the CAA. And when I speak about the Assam, the natural resources obviously come into existence, and the employment, which I think is the immaterial issue rising due to the misunderstanding of this act.
Okay, thank you so much.
Thank you, ma'am. Should I just close this browser?
Hello?
Hello?
Yeah.
Should I just close this complete browser, or how do I leave?
You just close the web page from here. Thank you. You may leave now.
Thank you.
Okay, now for the last time, team RNDC 010. Please enter the room. Please raise your hand so we can enter your room. Team number R3NDC 010. Team number 3NDC 010. Please raise your hand. Moving on, we will go for the session 3. Before the starting of the session 3, I would like to tell the rules again for the all participants of session 3. The rules are that there will be draw of lots to decide the order in which the teams will come up during the virtual room to present their debate. During the debate, time left will be shown on the screen with 2 intervals, which is when there's 3 minutes left and other when the time is over. The total time slot allotted for each team is 8 minutes. The team shall also shall decide the time limit for the speaker 1 and speaker 2. The minimum time for each member is 2 minutes. Speaker 1 will be for the motion and speaker 2 will be debate on against the motion. Suffix A with for the motion and suffix B for against the motion. Rebuttals will be included in 8 minutes given to each team. The team score will be calculated by both team members by adding both the team members' score. The language of the debate competition shall be English only. Use of web camera or face camera while speaking is mandatory for every participant. Reading from any written document is prohibited. If it is observed by the judge or the organizers, the team will be disqualified. Usage of any abusive or obscene language shall lead immediate disqualification of candidate. CLS skips shall be so discretion to assess penalties or to disqualify for any failure in abiding any foregoing rules. All team members refrain from disclosing their identity to their institution at any time or in any manner during the entire competition. Non-compliance with this rule shall result in immediate disqualification of the team. The decision of CLS skips in this regard shall be final and binding. Moving forward to the draw of lots. This is room 1, slot number 3. Our first team is R3NDC014. 3NDC014. Three NDC062. Our second team is 3NDC062. 3NDC001. Our third team is 3NDC011. Our fourth team is 3NDC012. Our fourth team is 3NDC012. Going further on, I would like to call 3NDC014 to raise their hand so we can let them in. Team 3NDC014, please raise your hand so we can let you in. Please switch on your video cameras. Team 014, please switch on your cameras. You are team number 104, 11014?
Yes.
Yeah, so please kindly turn on your cameras.
Yeah, give me a second, please. I think my webcam is turned on. Can you guys see me?
No.
No, you're not visible.
Okay, I'm so sorry. Give me a second.
Okay, not a problem. The other member can introduce herself by their team codes because you guys have entered with your names.
Yes.
Yes, please introduce.
My team code UNDC 014A.
Okay. Now, as you are both here, we may start now.
Shall we start?
Yes, you can start.
All right. Lack of education, lack of awareness, and most of all, lack of documentation makes the National Register of Citizens highly problematic, irrespective of your religious inclination. Good morning to everybody. This House questions whether Citizenship Amendment Law is constitutionally valid and a threat to the secular nature of the Constitution. However, this debate is not concerned with the combined effect of NRC and CAA. I firmly believe that when the Citizenship Amendment Act is judged on an individual merit without a hyphenation with NRC, it is neither unconstitutional nor does it attack the secular nature of India. From a 33% reservation in Lok Sabha for women, to a set number of seats being given to people belonging to backward communities in colleges, India has strived to eliminate discrimination since time immemorial through what is known as positive discrimination. Now you tell me, ladies and gentlemen, does the reservation to, let's say, women imply an attack on men? No, right? This brings me to my first argument in proving why calling the CAA unconstitutional is a logical fallacy. My opponents will come up here and claim that CAA is a brutal assault of equality guaranteed under Article 14. But what they very conveniently ignore is that this article does not call for absolute mathematical equality and brings to light the concept of reasonable classification. Now, what is reasonable classification? Any law which creates a reasonable classification, that is the existence of some rational nexus between the basis of the classification and the object which is to be achieved, is perfectly in line with Article 40. Whether it is Hindus being forced to convert to Islam in Pakistan or Christians being murdered in Bangladesh, the objective behind this act was simple: to deal with discrimination faced by minorities in 3 neighboring countries, which are Muslim majority countries with Islam as their state religion. Keeping aside the emotional turmoil and highlighting the legal proposition, it doesn't take a genius to comprehend that the purpose of this act was to never exclude Muslims, but focus on minorities who are clearly more susceptible to religious persecution in a Muslim majority country. It is baseless to assume that simply because Muslim illegal immigrants are excluded from this particular act, that they will not be given a fair chance or be denied citizenship completely on grounds of being a Muslim. What's even more surprising is the fact that an act which has no mention of existing citizens of India somehow discriminates against Muslim legal residents. When the Buddhist Dalai Lama and his followers had to fly to Tibet, India gave them asylum. When different groups of Jews wanted shelter, India welcomed them with open arms, only to show that India has and will always be a benign host to people of varied beliefs.
intention, which has a key role in establishing a crime, comes into play. What was the intention of the crime? Was it discrimination, or was it to protect those who may have needed more protection right now? It is unfortunate that what was initiated as a simple minority protection measure has been confused as an attempt to eliminate an entire community in a country that you, me, and even the government so proudly call secular. Thank you, everybody.
You may continue.
Yeah. Oh, can I start now?
Yes, you can.
Oh, I'm so sorry. Wait. Yeah. A government of the people, for the people, and by the people. But the question remains, if this government and this constitution is for all people indiscriminately or for a few cherry-picked sections of society. Keeping this motion in mind, I believe, ladies and gentlemen, the CAA was completely unconstitutional from its inception to its actual implementation in 2020. We live in a country that claims to be a constitutional democracy, yet has a flawed idea of human rights and citizenship. If religion becomes the basis to color refugee laws, this very democracy will be imperiled. The CAA has caused a shift from a framework that is religion neutral towards one that adopts religion as a test for citizenship. Are such changes constitutional? A clear and flagrant violation of equality guaranteed under Article 14. This law very conveniently singles out a religious community, infracting the very core of our founding fathers envisioned our country to be. One of the most commonly used and prominent defenses against this brazen attack on our constitution is the fact that Article 14 allows for there to be reasonable classifications while being implemented into a form of legislation. But the thing is, what makes this defense fall short of any logical consistency is the fact what makes this defense fall short of any logical consistency is the fact that these classifications are supposed to be pertinent, not whimsical, and the CAA fails to meet either of these requirements. The CAA fails to meet either of these requirements. It is important to understand that the legal attack against this one of the most what makes this defense fall short of. It is important to understand the legal attack against this act is not that it benefits the undeserving, but that it does not benefit those deserving similar benefits, leading to unequal treatment of equals. Ahmadiyas in Pakistan being constitutionally prohibited to pose Muslims, the history of the non-Pakhtun Shia Hazara being treated as slaves in Afghanistan. This act arbitrarily assumes that members of the Muslim community can never be targets of fanaticism or persecution in Pakistan, Bangladesh, or Afghanistan, which is clearly factually incorrect. Why does the state not feel the need to protect these communities who are also victims of persecution? Does this mean that we are denying non-Muslim minorities who have also suffered discrimination and even violence a safe harbor in India? No. But it is clear as daylight that the purpose of this act does not aim to protect those in danger because it has left out a group of people who are in desperate need of refuge and asylum very conveniently, making this classification completely invalid. My opponent, for the purpose of this debate, has decided to judge the CAA on its individual merit. That may sound appealing theoretically, but the fact of the matter is that no piece of legislation exists in a vacuum. It has to be taken and read with its implementation. Yay.
I'm sorry, your time is over. Thank you for such an informative debate. I would like to now ask judges if they want to ask any questions from you.
Sayed, were you reading something from in your laptop? That is
No.
what I was mainly observing that.
No, I think it's the angle of my webcam because my webcam is at the bottom of my screen, not the top. So that's probably why you thought so.
Okay. Regarding the Citizenship Amendment Act, what happens in case if a person from these three countries come after the date which has been mentioned, that is the 31st December 2014? Can he still be given? And what is the process for that?
Ma'am, no. The thing is that they can still attain citizenship by the procedures that were laid down before, I think, but they won't be guaranteed protection under this particular act, which is the CAA, right, or the amendment that was made. People who come after 31st December 2014, I think, was great.
So they are not being given a citizenship according to
no, ma'am. I am not exactly sure about what the procedure for them to get a citizenship here is, but I know for a fact that they won't be protected under the CAA.
Sure.
Ma'am, basically, this act is a fast-track method of providing those who came before that particular date the legal identity that they deserve because they were minorities in Muslim majority countries. However, if they do come after that date, their case may be considered for citizenship, but they will not be protected under the ambit of the Citizenship Amendment Law.
Then what is the purpose of the act then? I want you to go back. Once a second. Let's not waste time. I wanted you to go back to the same provision and look into the provision as to what exactly is the object and what in case if they have come before 31st December 2014 and what will be happening in case if the people are coming from these three countries after and what is the process for them to get the citizenship. I want you to go back and read it. Rather arguing something in air, I would rather not appreciate that. Okay, thank you guys. Thank you for joining.
Thank you, ma'am. Thank you, sir. How do we leave this room?
You can just close the tab.
Oh, okay. Thank you.
I request team member 3NDC062 to please raise your hand so that we could let you in.
Room number, team number 062 3NDC062, please raise your hand so we can let you in. Team number 3NDC062, please raise your hand. Hello. Please turn on your web cameras. Please turn on your videos.
Ma'am, am I audible?
Yes, you're audible, but you're not visible.
I've turned on my webcam. I don't know why. I'm not visible.
Try re-entering.
Am I visible now?
No.
No, you're not visible.
Now?
Yes, you're visible now. Please introduce yourself as your team coach and you may then start.
Okay, sure. Good
Good morning to all respected dignitaries and all the fellow participants. I'm Speaker 1 of Team 3ND062. Has my time started?
No, not right now. We will just start now. Can your other team members speak? I think so. Her audio is not.
Yes.
Yeah. So you're
Am I
from.
audible?
Yes, you're B and he's A, right?
Yeah.
Yeah. Your time starts now.
Okay. So, starting with today's motion, is Citizenship Amendment Act 2019 constitutionally valid or is a threat to secular notion of the Constitution? I say yes, it is constitutionally valid. Now, starting with my proposition. My point of contentions include following points. First, CAA is constitutionally valid under Article 11 of the Constitution. Second, CAA qualifies Article 14, which provides right to equality. Third, CAA complements Article 21, which provides the right to life and liberty. Now, starting with my arguments. This law is concerned with providing citizenship and protection to persecuted minorities from Pakistan, Bangladesh, and Afghanistan on the grounds of religion. This law doesn't hurt the secular nature of the Constitution. Rather, it aggrandizes the humanitarian status of India. The amended act just proposes to provide easy access to citizenship to certain criteria of persecuted religious minorities who have been facing extinction level atrocities. It does not prevent any individual to gain citizenship, any individual refugees from any country to gain citizenship through standard process of law. To criticize this amendment is akin to criticizing the countries which allowed the entry of Jews in mid-20th century. Okay. Now, stating my points, Article 11 of the Constitution of India authorizes Parliament to make any provision with respect to the acquisition and termination of citizenship and any other matter regarding the same. Any provision which distinguishes between two groups may violate the standard of equality guaranteed under Article 14 of the Constitution, unless one can show a reasonable rationale for doing so. In right to equality under the Indian Constitution, there is some disturbance. Okay, it's clear now. In right to equality under Indian Constitution, equals are being treated equally and unequals are being treated unequally. The same phenomena is applied to justify the concept of reservation system in India. A citing example of Article 30, where minorities are eligible to establish religious institutions of their choice. Third, religious minorities are being killed, people are being abducted, mass murders are being taking place, forced conversions of people. These incidents are common in these three countries. Seeing today's examples like the condition of Sikhs in Afghanistan and some related examples, we can imagine the long-lived enormity which has been perpetuating in these countries. So, on humanitarian ground, providing livelihood, providing security, providing safety, providing prosperity to oppressed minorities, this law upholds Article 21, right to life and liberty, which has been constantly neglected by the mentioned three countries. So, concluding my statements, India is one of the highest refugee procuring countries. India has been providing security and safety to many different communities in past, and in future also it will provide. This law passes all the tests of passes all the tests of constitutionalism and on humanitarian grounds. Reiterating my stance, this law is completely constitutionally valid and is not a threat to secular notion of the Constitution. Thank you so much.
A very good afternoon to honorable panel, and as my knowledgeable contender, he pointed out Article 14 and Article 21 of the Constitution. Now, let me not give example of other countries and rather fix my entire attention on the topic that is related to this secular nature of our Constitution. Now, in the secular nature of our Constitution, it is clearly mentioned that the government has to make sure that there is equal representation of each and every religion. Now, on the grounds of that, the government has to provide methods so that minorities in all the 6 minorities that are mentioned, as well as the Muslims, they are at least represented in front of the law, as it has been given in the Article 14 of the Constitution, that each and every person, and in person here it includes both Indian citizens as well as foreign nationals, that are represented equally in front of the law. And when I talk about Article 21, it talks about right to life and liberty. So now my question is this, that how can you say that there is a right to life and liberty when a particular section of the society, that is Muslims, are not represented? And one major thing is that in this Citizenship Amendment Act 1955, there is this word naturalization mentioned, which is the basis of selection of citizens. Now, of course, people will be requiring documents in order to prove themselves to be citizens. Now, how can you be sure at the ground reality that each and every person, whether they are, poor people, they have the required facilities or the documents so that they put in front of the government? The thing is that this act is open to various ambiguities, and there could be a possibility that it is a garb of fascism. So that's what is the major drawback of this act, that rather than taking religion as a ground of selection of citizen, the government could have focused on other methods also, such as political prosecution, social prosecution, or economic prosecution. Thank you so much. Any questions, Alpesh?
Yeah, I want to ask to team number A of the team, the consideration that you referred to defend the CAE, that on humanitarian consideration, India is accepting the people who are persecuted elsewhere. So is it purely humanitarian consideration or it is religious consideration? Because even other religion people could be used as well.
Sir, I've also mentioned see the purview of CA is mainly religious. Okay. So to add one extra point as religious minorities being persecuted, so adding a persuasive value to my arguments, I've mentioned this point that on humanitarian conditions where right to life and liberty of people of minorities in certain mentioned 3 countries, which is being constantly neglected. Mass murders, forced conversion, abduction of women, abduction of males, to completely extinction level atrocities being taken. So I'm not saying that the CA, I'm justifying CA mainly on based of humanitarian grounds. The purview of CA is religious and humanitarian as well. Thank you, sir.
Mr. 062A, I would like to ask, even the Article 14 says that no state shall deny any person, right? When it doesn't say the state shall not deny any citizen. So don't you think the act will be mainly discriminatory towards a particular religion? How can you really substantiate Article 14?
Ma'am, I'm saying there's a rational, reasonable rationale given to it. See, the probability, it is highly unlikely that Muslim majority countries, Muslim can be prosecuted. While seeing recent examples, we can see the overall situation which minorities might be facing. It is highly unlikely that in Muslim majority countries, Muslim might be facing persecution.
Okay. Miss 062B, when there is already an Assam Accord being done, why exactly there is so much of agitation and the protest going on there? They have been already given a special status. Yes, ma'am. What I have read, according to my knowledge, is that the protest is according to that the resources are very less there.
and the people are agitated that there are chances in future that those resources can be given to other people who are coming from the outside. So they want that at least.
But already there is an inner permit, right? There is an inner permit which they have to take before they enter into the premises, or even if it is for tourism, they have to mainly abide by the inner permit, right? They have been given that special status. Then how can you say that the people who are coming, from elsewhere would mainly take away the resources per se?
Ma'am, that is what I have even pointed out, that this entire act is quite ambiguous in nature. I cannot predict anything, but these things could happen in future.
Okay, thank you so much.
Thank you so much.
Thank you, ma'am.
Thank you.
Thank you, sir.
You may leave the room right now.
Okay, thank you so much.
Thank you.
Now I would like to call room 3NDC001. Please raise your hand so we can let you enter. Room team number 3NDC001. Please raise your hands. Let's join.
I think we have to be a little quicker because I think we are running short of time. We are already getting to 1 o'clock and we are still in the session 3.
Yes, ma'am. Sorry, we will just it's taking a little more time. Please switch on your cameras. Please, both of the team, please switch off the camera, switch on the cameras. You may introduce yourself and then your time will start.
A very good afternoon to the House. I am Speaker A, and I will be speaking for the motion of the Citizenship Amendment Act 2019. Okay. So like I said, I pointed out that I am pro Citizenship Amendment Act 2019, and my stance on the topic is that it upholds constitutional validity, and I do not believe that it violates any of the constitutional rights as per se, and I do not believe that it threatens the secular notion of the country. Now, speaking of the constitutional validity, it is often assumed, or the topic of debate is more towards this controversial topic of Article 14. There is an assumption saying that Article 14 is being violated by this particular Citizenship Amendment Act 2019. Now, as we all know, Article 14 says that no state can deny any person equal protection of law or equality before law. Now, we need to further emphasis on two parts of this particular article. The first being, like I said, that the state cannot deny equality before law to any person or equal protection of law, and hence does not allow discrimination. Now, this is a negative aspect of the notion, and we shall rest it there. Now, coming to the second part that I would like to emphasize is that the same constitution also says that it requires the state to provide special treatment in order to uphold the rights of certain minorities. Now, this will bring us down to the fact that the same constitution allows the state to formulate special treatment for the minorities, which again results in the concept of reasonable classification. Now, as per the reasonable classification, the state, in order to put forth any law, it needs to basically satisfy two conditions. First being that there needs to be an intelligible differentia, that there needs to be a certain valid reason as to why a particular group of people are being differentiated from the rest. The second being that this particular differentiation needs to have a rational relationship with the objectives of the bill. In the said matter, the objectives of the Citizenship Amendment Bill is to, in the spirits of the bill, is to protect the minorities that are religiously persecuted. Now, having said that, given that the three countries that are opted are Afghanistan, Bangladesh, and Pakistan, which are known to be Islamic states. Furthermore, the six groups that are chosen out of these three particular countries are non-Islamic groups and non-Muslim groups. Having said that, it's obvious that there is a rational differentia picked up. The group differentiated fits in the description, and by this we can say that the two requirements are satisfied. Furthermore, we should also emphasize on the fact that equals must be treated equally and unequals cannot be treated equally. Now, given that in this particular situation, these six communities are repressed rigorously, and giving them the privilege of cut down of the years from 11 to 5 in order to gain citizenship is actually keeping them at par and giving them an opportunity to be treated equally rather. Furthermore, it is also assumed that in case we say that Article 14 is being violated, we fail to recognize that the amendment clause of 6B also says that these particular people who enjoy the privilege are given enhanced obligations. Will it not violate Article 14 then? So the question here is that we need to understand that the equals cannot be treated unequally, as well the unequals cannot be treated equally. Now, coming to the second part is, why have we chosen the three respective countries, that is Afghanistan, Bangladesh, and Pakistan? Now, going back to the history, we should be aware of the Nehru-Liaquat Pact of 1980, in which the two countries signed a bilateral treaty saying that they would uphold the rights and interests of the minorities in their respective countries, basically like leverage. But the statistics show that in India, the Muslim population has risen from a mere 10% to 14%. But on the same hand, in Pakistan, it has come down from almost 20 to 1.85%. And the same goes with Bangladesh. Now, given the urgent need of protecting human rights, the government of our country has upheld this particular Citizenship Amendment Act of 2019. And I strongly believe that it does not curtail or violate any of the constitutional provisions let out by our Constitution of India. Thank you.
Hello, moderator.
Yeah, please carry on.
No, before that, ma'am, I just want to ask the moderator if we have 3 minutes left as a team or...
as a team.
As a team. You have left as a team.
Okay. Thank you. I think I'll just make this short. I'm audible, right?
Yes.
Okay. Good afternoon, judges and my co-participants. Me being of team NDC 001B would like to say that there is a major threat to secularism that is brought in because of the CAA amendment bill. Now I'll be basing this on 3 arguments because of the lack of time. The argument number 1 that I'd like to pose out is the question of equality. Now, the idea of equality is clearly being violated over here because the main argument or the main justification that is being used by people who supports CAA and the government itself is the idea of protective discrimination, which in a sense is the idea of giving some people a little bit of extra help so that they can come up to a point where they can be treated equally, because they are unequal because of circumstances that are not their own. Now, the problem with protective discrimination that is that in its root, it is still discrimination. It is the idea of prioritizing one person over another. Despite it being used for philanthropic reasons, it still goes against the letter and spirit of what equality stands for, and that is in a sense the equal treatment of two people. The second point I would like to bring up is the idea of a theocratic law. A theocratic law, in a sense, something that is focused mainly on the idea of religion. Now, let me define secularism. Secularism, under the Oxford English Dictionary and by the under Indian codified laws, is the belief that religion should not be involved in any legislation, in any process, or in any action taken by that society. In essence, there should be no religious motive, there should be no religious understanding, no disadvantage. Basically, religion in itself should not be a concept that sort of aids or brings down a certain policy. In our case, if you look at Section 2 of the Amendment Bill, it clearly does not mention the religion of the Muslim religion or Islam in essence. And that in itself goes against what secularism stands for. The idea that religions are being given priority, that religion A, B, C, D, E, in our case, Hindus, Christians, Jains, Parsis have been given more priority compared to a Muslim, on the basis that just because there are certain Muslim sects being, certain Muslim societies, certain parts of Muslim societies being oppressed in those countries, because they have a constitution that is essentially based over Islam. Okay, with that, it's certainly based over Islam. But that I just like to conclude by saying that the entire law is theocratic in nature and in a sense harms equality and harms secularism, which happens to be the spirit of our constitution and our country as an idea. Thank you.
I would like to have a question for Ms. 001A. As you spoke about the historical aspect, what exactly was been signed in 1972? A similar pact was been signed, right? Wherein almost 1.2 million refugees were absorbed by India. Could you refer to that? What exactly, because as it is mainly referring to what exactly you're saying in your historical aspect. That is my first question. Second, when you talk about, taking, you're saying as it is not violating Article 14. So in case later, after a few years, in case if any of the other religious persecution happening in other countries like Sri Lanka, whether your government would accept them also? You are not audible?
Am I audible now?
Yeah.
Yeah. I would like to address the second question that you asked me. So basically, the assumption saying that future this is based on a mere speculation. It is, we are speculating matters and creating, this holds no water in the eyes of the law. It is mere conjecture, and we can go on arguing about possibilities in the future, but given the circumstance at the present, I believe that it is not violative of Article 14. And ma'am, could you please repeat the question about the Sri Lanka?
Like in case if any religious persecution is happening in Sri Lanka, whether they can also be a refugee, they can also come to India and they will be accepted as refugees under the said law. And is there any clarification given by the government? That is more important regarding this.
Okay. First, I would like to quote this phrase that if a law is passed to tackle one evil, there is no obligation for the law, for the state to pass on similar such laws to tackle similar such evils. So said that, I believe that within the ambit of this particular issue, since that it is given religiously persecuted, and the countries in matter are very clearly given. So given the ambit of Afghanistan, Bangladesh and Pakistan, we can give a clarity based on if they will be allowed or not. And the other countries apart from these are not even the objective of the bill. So we are not inclined to talk about it.
Okay, my next question is for 001B. When already there is an Assam Accord, under which clause are you mainly the they are being protected. You're talking about Assam Accord. There's so much of agitation happening and protest happening in Assam. You have been already given a special status under the Assam Accord. I hope you're aware of that. 001B.
Judge, I have not mentioned about the Assam
No,
Accord. I did not reach that point.
No, but I'm asking you, if you're saying it against the motion, right? But when you're saying it is against, majorly there is a protest going on in Assam. When a special status is given to Assam, then why exactly are you all opposing against the motion?
Judge, the question here is with regard to CA and what it holds to the religious minorities that are in question. With regard to the riots and the protests in Assam, a lot of it has been fueled and has been proven to be fueled because of people of outside sources. And in essence, there's not a lot of education that has been shown as to what it is, and Assam is under Schedule 6, I believe, of the Constitution, which comes under NRC and not CA. And the question here is that we're talking about the validity of CA, and I strongly recommend that we do not get both of them confused in the first extent. And while debating the secular nature of both the things, it is clear that there is a priority that is being shown from the side of the government as to pick which religion is allowed and which isn't. No matter what their objective is, no matter what they say, there is a damage to secularism at the base level, and that qualifies to being an infringement on the secular idea that the Indian Constitution provides. It can be for any reason whatsoever, but if there is an infringement, there is an infringement. That's essentially the basic principle. And that's the point that I was trying to bring up.
Fine. Thank you so much.
You're welcome.
Okay. Now I would like to team number 3 NDC 012 to raise their hand so we can let them in. Team number 3 NDC 021. Please raise your hand so we can let you in.
Paril, it is 022 or it's 012?
012.
Okay.
Sorry, ma'am. Team number 3 NDC 012. Please switch on your web camera. Team 012, please switch on your camera. Where is the team member 021?
He must be.
Oh, is his name Kumar Shiva?
Yes.
Yeah, so I've entered him. He will be.
Okay.
Meanwhile, you can introduce yourself to judges.
Okay. I'm going to speak against the motion, and my team code is 3NDC012B. Hello? Huh?
Kareem, can you, this is a small request because we are running short of time and we don't have to wait for the students. It is they have to be in the waiting list. We don't have to wait for them.
Yes,
that is the major rules they have to follow. If they are not, we can switch to the next. Let them come at the end. This is not the way we have to wait for the students. They should be very punctual enough for the competitions.
Ma'am, one member has joined due to some connectivity issues.
Yeah, but that is already mentioned in the rules. It's already mentioned in the rules. We don't have to wait. If you start giving them so much of leverage, then they won't never be serious about the competition.
Okay, ma'am. We will just tell them that we will just giving 1 minute to them. Okay, just coming. I've just allowed them. Sorry, ma'am, for the inconvenience. Please turn on your cameras.
Is there a possibility to keep the next team in the waiting while this team is speaking, so that as soon as they finish, you can put them on?
Okay, so
you can ask even 022 to be logged in now, and you can keep them in the waiting room while 1-2 is talking.
Okay, so sir, this is the last team for this session. 022 is absent. They are not present here. So this is the last team, that is 012 for this session. Okay. The next session will be continue after the break. Okay. Okay, so we will do this in the next slot for sure. Thank you, sir. Sakshi, team code 03012.
Yes.
Is there any problem with your team?
Yeah, he's facing problem in joining.
Okay, so what kind of problem he's facing?
I don't know, he's saying that he's unable to join.
Okay, wait a second. I will just see. Yeah, he just came right now, like 021A. Tell him to join again.
Yeah,
okay.
yeah.
Okay, now he has entered. Let's join the room. Please turn on your cameras.
Just a moment.
Okay.
I can't get the option to switch on the camera.
You're from your phone or you're from your laptop?
Yeah, I'm on for my cell phone.
You're on your cell phone. Okay, look left and above. Look at your left.
Okay. Yeah. Thank you so much.
Okay. Now you may continue and introduce yourself, and your time will start.
Sure. Good afternoon, respected jury. This house believes that whether the CAA is constitutionally valid or is it threat to the secular nation, country India. First of all, it is constitutionally valid. When we talk about the constitutional validity of this CAA, first of all, let us understand what is CAA and what is NRC. NRC is something different, CAA is something different. And that's why the opposition or the layman or the people who are not very much aware of these two things, they are just clubbing this thing and making the issue out of this, that okay, this is something which is hampering the temporality of their own identification. First of all, CAA is only for the Citizenship Act, which will give the citizenship to the minorities who are from the 3 countries, the 6 communities. Why they have been given this citizenship? Because the explicit minorities, when the Delhi Impact, the Liaquat Nehru Impact was signed, which is also known as Delhi Impact. When this impact was signed after the freedom, so n number of people, n number of the person's identification, they crossed the borders and they came to India or they went back. So the minority treaty was signed so that how they can be treated as and they can be given the equality for the minority thing. And when the CAA, what is CAA? CAA is only which is, will be giving the citizenship title to the persons who are the foreigners who came to India without visa or whose visa has been over, but they are illegally being staying over here. But that also, if they have been here before or on from 31st 14. First thing. Second thing is that NRC is something different, and that's why they are taking this plea for the hampering of the identification thread. The opposition or the person, the people, they are saying that this CAA is violating the fundamental things of Article 14. When we talk about Article 14, yes, Article 14 says that any person, but any person also, they should not forget or they should have this thing in themselves that yes, the constitution itself says that the parliament and they have got the exclusive power to make laws and to execute laws for the same. And what about Ahmadiyas? Ahmadiyas were the one who decided to go and form their own branch of chain with their own majority, which are in the Muslim countries now. That time Pakistan, and then East Pakistan, which is Bangladesh, and then Afghanistan. And why these six religions from three countries, six communities from three countries are being given this citizenship title over here? Because they are being treated as the aliens. When the treaty was signed during the Delhi Pact, the Liaquat and Nehru Pact, why they are being given the illegal threat to their identification, that as if they are aliens or something like that. So Article 14 CAA is not violating any Article 14, and according to CAA, the Citizenship Amendment Act, according to Article 10 and Article 11 of the same Citizenship Amendment Act, it is fulfilling all these things, and also along with the Constitution, it is also fulfilling the Article 246 provisos and procedures that exclusively execute the plans and execute the powers, execute the laws. And also, to be very honest, the last point, whosoever the opposition or whosoever the lame people or the layman, which we say, if they are saying that this is violating the Article 14, let's not have the discussion over the things which are not in the control of all. If it is violating Article 14 with the concept, with the weapon which they are using as this person thing, if they are using this as a weapon, and if they're countering the government's ideology and government's contention to have the Citizenship Amendment Act, let's have this from the judiciary precedents, and let's leave this on the part and on the precedents which are prima facie dealt by the honorable courts. So at last, Amendment Act violating any Article 14, it is not violating anything, and it is 110% constitutionally valid according to the contentions made by me. Thank you so much, jury.
Zero 012B, please carry on. You have 3 minutes left.
Sakshi, 0213B. Yes, you may carry on.
Our constitution is secular, and this Amendment Act is an unconstitutional act which is affecting the dynamics of our country. The preamble, the preamble of our constitution itself
The voice is breaking. Sakshi, you're not audible.
Zero to 1 to A, you may tell your teammate that there is a connectivity issue on her side. 0 to 1A, you please convey this. Or you
continue. I'm so sorry.
You can continue.
CA is clearly against the secular principle of this country because it tries to establish that for non-Muslims from outside the India, it's their natural home. The CA represents a fundamental break from the core.
You're not supposed to read, Sakshi. You're not supposed to read.
I'm sorry, ma'am.
You're not supposed to read. I hope you're not reading from somewhere there.
No, I'm not.
Okay.
The CA represents a fundamental break from the core principle of the Constitution to all without discrimination on the basis of religion, language, race, ethnicity, or gender. India
Okay, 0 to 1 to A, you may conclude now from your partner's side.
Conclude from my partner's side.
If you want to conclude on the entire debate.
May I continue?
No, the partner is still there.
Okay, then continue. You have you don't have a lot of time.
Okay. The CA is violating the text of the Constitution, but also going fundamental against. It allows certain illegal migrants to apply for citizens, provided that first it came to India before. First, the people who came to India before 31st December 2014. Second, the people who were exempted from the Passport Act and Foreigners Act from the Union government. And third, the people who were from these three countries, and fourth, people who were from 6 communities. Then the purpose of the law is to protect the members of these 3 communities from the these three countries who have suffered who are suffered from religious persecution there. If the law is for the people who suffered religious persecution, then Rohingyas are also persecuted in Myanmar. The UN has declared the Rohingyas crisis in Myanmar as the most worst humanitarian crisis. Basically, I would like to say that
I'm going to stop you. Time is over, and we are already running late. Any questions that any of the judges want to ask me, please ask.
Yeah, firstly, I would like to ask Miss 12B, when you're saying against, so already there is an Assam Accord, which mainly clauses has been told, what exactly has been mentioned in the Assam Accord, and which clauses mainly protects these, tribal communities?
Okay, ma'am, firstly, NRC and CA is purely...
No, come directly to the answer. I don't want any explanation because we are running short of time. Can you directly come to the point? My question is very straight and objective.
Okay. So, ma'am, and about CAA is talking about for the people it's not only restricted to the
If 12A can also take up in case because she has a technical issue, you can also answer. 12A.
Sorry, respected jury.
In case because she has a technical, your co-partner is mainly having technical
Jury,
issue.
since this house is not.
What exactly Assam
yes,
protects? How exactly?
Respected jury, this house is not very much. No. Your jury, respected jury, this house is not very much prepared for the NRC part, since this is on totally on CAA, whether this is constitutionally valid or is it threat to secular nation. So let's not talk about the NRC part, because NRC is just for the registration and listing of the same. That's it.
Okay, but exactly what I was trying to ask is, because of the CAA, there was a lot of protest going on in Assam, right? So I wanted to mainly ask you why exactly there is a protest going on when they have already been given a special status. That is why I mainly try to ask you on a direct question, which I think you could not get it. Okay, thank you for joining with us.
Yeah. Respected jury, I'll tell you that thing. Because they are afraid and they're in a fear of that their identification may lose. Because since when East Pakistan was formed during 1955 and the Bangladesh, the minorities from there, the majorities of the Muslims were there, and there was a depression part, actually, the suppression part of it, the same. So that's why this is not very much connected to the NRC part with the CAA, because CAA is something else, NRC something else. But due to the combine of both these things, the havoc has been created. That's it.
Thank you for joining.
Okay, you may leave now.
Thank you so much.
Thank you, ma'am and sir, for sparing your precious time, and we are extremely sorry for the inconvenience and for the delay. Now there will be a break for an half an hour, and the next session will begin at 2.
Tanveen, I have only one request: keep them waiting in the waiting room so that we don't have to waste time for them waiting, because we are not giving more time for discussion, neither for question, because we are short of time, but we are wasting more of the time only waiting. So let them keep waiting in the waiting room, and we can take immediately one by one, so that we can give some more extra time in case if they are having questions, or if we have certain things to discuss, or rebuttal or rebuttal. If we ask anything, let them answer back. But let's not waste time just for waiting for someone. That would be, and just keep them waiting in the waiting room. That would be, the way we can go forward for the last session.
Okay. Thank you, ma'am.
Yeah. Thank you so much.
We have to join in again, right? Or we can be online and take it.
You can join. You have to join, sir, as a judge. You can join at 2.
Okay.
Thank you so much. Thank you, ma'am.